trouble. And we'll reconvene. And would you like to come back up because we interrupted you right in the middle of your presentation and finish what you had to say to us? Okay.
I don't really have anything left to say to you guys unless you have anything for me.
Okay. Do any of the commissioners have questions? Okay.
I have questions.
Go ahead.
Did you have a conversation with Mr. Groh on or about February 17th of this year?
On the phone?
Yes.
Yeah. He called me and told me there was some photo discrepancies.
Did you tell him that the date on those photos, which is April 11th, 2015, was created as a historical recreation of cannabis cultivation in previous years?
Yeah. No, I didn't tell him that. Sorry, no, I didn't tell him that.
So you're telling us that that date's accurate? That's the
The
date?
date that we drilled those holes is accurate, yes.
For the grow that's shown on the August 20th, 2016 aerial, the grow you actually did,
Yeah.
did you drill holes for that?
No, we did it in pots.
So, okay, so you didn't need any holes for that?
We didn't need any holes, no.
Okay. The holes that are shown on your April 11, 2015 photos, how many holes are those that you drilled back in 2015?
Probably close to 70 or 80 in that picture, I would say. I was gonna do 99, but I don't know exactly how many were in the picture. I can tell you.
How many plants were you going to put in each hole?
One.
So how many square feet of canopy would you get out of those holes?
If I had to measure
Best
them out, I'm
estimate.
gonna have to say they're 10 feet apart, so 10, say we got 99, that's 10,000 square feet, probably roughly right in there. 1,000 by 1,000, or that'd be 100 by 100. If I did 10-foot spacing, you know, and I think that's what those holes are spaced out at.
So that would have accommodated, say, 10,000 square
Yeah.
feet. Thank you.
Thanks.
Are there any other commissioners that have questions? Okay. So at this time, did you have any rebuttal you wanted to?
Yes, I would like to rebut that statement that Mr. Moore just made. That is not my recollection of that conversation. He did, in fact, claim that those photographs were historical recreations. And I would like to read from my letter of February 17th, which recorded that conversation with Mr. Moore, if you'll allow me to. I asked Mr. Moore why I did not see the augured grow hills shown in his evidence photos of April 11, 2015, or other evidence of cultivation or grading in the aerial photography. Mr. Moore explained that the holes were made along the drainage leading down from the stock pond to the corral area. He also explained that he had been growing for years under the trees in the draw, a dozen or two plants each year. I explained that our aerial image of June 3rd, 2016 did not show any signs of earth movement or cultivation in that area, but our aerial image of August 20th, 2016 plainly showed the cultivation site developed this year across the draw from the corral. Mr. Moore then explained the photographs were taken in 2015. I pointed out to Mr. Moore that the requirements for evidence photos was only created in early 2016, so I did not understand why he would even have photos of this activity from April of 2015. Mr. Moore then explained that he did not have any evidence photos when he became aware of the requirement and deadline date. So the date on the photo, April 11, 2015, was created as a historical recreation of the cannabis cultivation in previous years. I explained to Mr. Moore that most likely this would lead to a denial of his registration based upon submitting false and misleading information and failure to show demonstrable steps taken towards cultivation prior to May 10th, 2016. It's my rebuttal to Mr. Moore's statement.
Any questions? I mean,
No?
I'm good if you guys are.
Yeah, he has a question for you. If you could hold on just a moment, please.
Yeah, I think I've heard 2 or 3 different versions of this same question answered. Let me try one last time. Exactly what date was the photograph labeled April 11th, 2015? What date was it actually taken?
It was taken April 11th, 2015.
So it's not a recreation of a historical thing, it's what actually existed then.
We were gonna grow that year and we backed out because of financial issues and because of the law. So, that's all I got.
All right, thank you.
That was not explained to me on the television in our discussion. That he had actually drilled those holes in 2015 and that he had filled in.
And did he ever tell you he had filled them in?
No, absolutely not.
Not ever before today?
Never, ever. This is the first I've heard of it today.
Okay. This time we'll take public comment on this agenda item. If anybody has anything they'd like to say? Okay, if there's no public comment, we'll bring it back to the commission for discussion.
Okay, I'll lead if you want.
Okay?
The, the code is pretty specific on what you have to have. And you have to provide evidence satisfactory to the planning director that no later than May 10 of 2016, you've taken demonstrable steps towards the development of a commercial medical cannabis cultivation site on the parcel as described in one of 2 ways. Either date-stamped photographic evidence of cultivation commensurate with the area proposed to be cultivated, or grading or earth moving commensurate with the area proposed to be cultivated. We do not have before us any date-stamped photographic evidence of cultivation. We have no evidence of grading. Now, if drilling holes counts as earth moving, I think it would have to be for the grow for which the registration is sought. In other words, you're seeking registration for the 2016 crop, and the holes that were drilled in 2015 were all filled up. There was nothing there. And even if the 2015 photos counted, which I don't think they should because they got filled up and they didn't exist for the 2016 season, and you didn't need them for the 2016 season because you grew in pots and not holes, so they're kind of irrelevant. But even if they were relevant, they're not evidence of earth moving commensurate with the 22,000 square feet that you're trying to get registered, no more than 10,000. So under the language of the ordinance, I don't think that this application can qualify.
Well, I'd add that I think Mr. Moore has taken a common sense look at, well, if I'm going to invest all this money, why, I want to make sure that I have a permit. And so I'm going to hang back before I do anything and see if I'm going to get registered. Unfortunately for Mr. Moore, the entire gist of this ordinance was to stop cultivation where it was as of May 10th, 2016. That's very clear in the ordinance. And that's why we required, or the county has required, there to be this photographic evidence that you already were, as of May 10th, cultivating or had taken great steps with grading or whatever to be ready for cultivating. And so even though I think Mr. Moore's approach is a common sense investor type approach, it is directly contrary to the gist of the statute. And so I think we have no choice but to deny the appeal.
Anything further? Okay. I think my concerns would be that on the plot map, it showed us where the intent was to grow. There was no evidence that the grow was there previous to that. And I understand that you said you were growing under the trees. As you registered, it should have been registered as the plot map growing under the trees, because in essence what you have done is moved the garden from after that May 10th date. It was in the tree line. You moved it out of the tree line, and it doesn't show evidence that you were growing in that spot previous. And the whole point of the ordinance was to be growing and submit what you were growing and showing proof of that. It's unfortunate because I don't feel like proof has been brought forward to us to support that evidence per the urgency ordinance. So at this point, if there is no further comments, I'd like to call for the reading of the resolution, please.
Madam Chair, I'd like to just get something on the record,
Okay.
just so it's part of today's record. The story that we understood the picture to be has changed. And maybe it was misunderstanding on Mr. Grove's part, maybe not, I don't know. But what we thought was that these pictures were taken later. The date was added as to what they were purporting to be back on that date. Now I hear that, no, these pictures were actually taken on April 11, 2015. I find that a little hard to believe because what I'm seeing here is dry grass, clearly taken in the summertime, not in April. This grass here would have been green at that time.
It's been a drought for 10 years, bad drought. We haven't
I'm sorry. Public comments closed.
I live in this county too, and even in April, even during the drought years, there was sparse green grass on the ground. This is clearly not taken in April. And so I want to so affirm our position that these were false and misleading documents, and that's one of the findings in the resolution, and that's why we still support that statement.
Well, I think they're clearly misleading because there was no explanation from Mr. Morris along the lines of what he's telling us now, that those particular holes had been filled up by the time he submitted the photos. They didn't exist. And I think, as Mr. Laddish pointed out, the natural implication when you look at those photos is to say these holes are in existence as preparation for my current grow. And they weren't. Clearly
I
were
agree,
not.
he covered them back up, and in 2015, he said that he grew on the draw. So he drilled those, he covered them back up, and then he grew somewhere else after he did that also.
So I'm comfortable with the finding in the resolution as it stands.
Okay.
I have one suggestion on the resolution. I don't know if this is the time to make it. In the number one finding, the last sentence that says the registrant failed to provide date stamped photographic evidence, I'd insert the word acceptable before date stamped. He did supply evidence that had dates on it.
Acceptable,
This-
date stamped photographic evidence.
That's what I'd suggest.
Okay.
Okay. Would you like to read the,
Very good. I would like to read the recommendation. Staff recommends that the Planning Commission adopt a resolution 2017-021 denying appeal 2016-827, thereby upholding the planning director's determination to reject the application 2016-827.
As amended,
Excuse me,
as amended,
as amended, correct.
so moved.
I'll second that.
second? Thank you. All in favor, say aye.
Aye.
Opposed? Motion carries 5-0. You want to read the?
Yeah, and this action is final and it's appealed within 15 calendar days from today's date.
Okay, the next item on the agenda, number 3, under public hearings, appeal of planning director's denial. And Paul, you're also representing this one?
Correct.
Okay. Just to make note, this is one that was continued from our March 23rd meeting.
Yes, that is correct. Mr. Lopez. This is 959, correct?
Yes.
Yes.
Thank you. This is not
Oh, I'm
Scott
sorry.
Lopez and Justin Ecker.
Lopez and Eckert, yeah.
Yes. Okay.
You can wait until he's done with his presentation and then you can come up.
3 was Mention.
Oh, my agenda reads differently. Hold on just one second.
Okay, very good.
I had Joshua Moore, and then my agenda says Scott Lopez, but he's stating,
No, it's Scott Lopez.
what is that?
That's the minutes from the last meeting.
Yeah. I'm
Okay, so
very sorry, Madam
that's-
Chair.
We're on Scott Lopez and Justin Ecker.
Very good.
You know, I'm so easily thrown off. You can't do that.
Okay, this is appeal number 2016-959. Scott Lopez and Justin Ecker are appealing the denial of a commercial cannabis registration by the planning director. Project description, again, in appeal of a denial of a commercial cannabis registration by the planning director. The registration was denied for the following reasons. First, the registrant did not demonstrate lawful possession of the parcel to be registered prior to May 10th, 2016. And second, the application for registration contained false or misleading information. And just to locate ourselves here, this is a 10-acre site located at 5348 Messing Road in Valley Springs. It's in Township 4 North, Range 10 East, and in Section 30. That's in District Number 1. On the location map here, that is the parcel. Oh, okay. Pardon me one second, guys. This is the parcel right here in Messing Road. If you go back this way, the actual backside of Valley Springs is over here about 4 or 5 miles, Highway 26. But if you go up Messing Road and then east on Highway 12, you'll find yourself in Burson. On June 30th, 2016, the applicant Scott Lopez and Justin Eckert filed a commercial cannabis cultivation registration for 22,000 square feet of mixed light cultivation area. I'd like to proceed to the first cause for denial, and that was that the applicant failed to meet the requirements of Section 1795-165 N2B, and that reads as follows. Number 2, the registrant must provide either B, a signed and dated lease demonstrating the registrant's lawful possession of the parcel to be registered prior to May 10th, 2016, and his or her current lawful possession of the parcel. The registrants did submit a handwritten statement by the landowner, Shane Cartwright, which you see on the screen right here. In the statement, Cartwright states he has leased a portion of his land to Lopez from April 3rd, 2016 to November 28th, 2017. The statement is not dated, it is not signed by the tenant, and does not identify the property to be let. This document, when it was submitted, was reviewed by planning staff and deemed not acceptable when it was submitted. The registrant was asked to resubmit a valid lease. Subsequently, the registrants submitted The following lease we see right here, a California residential lease agreement. It is dated and executed on June 3rd. It's a little hard to tell, but up there it is entered into on June 3rd, and actually all the execution signatures here by both the tenant and landlord are on June 3rd, 2016. This lease also does not identify the property to be let. In section 1 right up here, you'll see they left that blank, so we don't actually have a physical property identified in this lease. Its commencement date right here is May 3rd, 2016, which actually predates the actual execution of the lease on June 3rd, 2016. Now, the appellants in their appeal letter of February 24th state they dated the second lease agreement to reflect the dates in Cartwright's original handwritten statement. Further, they state that planning staff directed them as to a date to use. The appeal letter also states a corrected lease and a copy of a note by planning staff giving directions for the revised lease would be attached to the appeal letter. Those attachments did not come with the appeal letter. I requested them from Mr. Lopez and Mr. Eckert, I believe 3 times, and they were not provided. And to the statement that planning staff directed them as to a date to use. In the appeal letter, planning staff is identified as a she. I asked Madeline Flandreau, Gina Catan, and Deborah Lewis in our office. People who could have been the she, whether they were familiar with any of this activity, and all of them said this situation did not sound familiar to them at all. Because of the inconsistencies and incomplete content of these lease documents that the appellant provided, staff wasn't provided with sufficient evidence that actual lawful possession of this property had been taken by the registrant prior to May 10th, 2016, and as such, it failed to meet Section 1795-165 in 2B. Proceed to the next cause for complaint here. And before I actually read that, this is an actual, this is a county aerial taken August 13th, 2016. This is our parcel right here. And the parcel actually has a residence in front and a residence in back. We are going to, in your staff report, you had 2 pictures, 2 photographs that showed dry yellow grass. We're going to look at, I believe, 7 altogether, 5 more. And those photographs are going to have been taken down here in the backyard of this house or the side yard of this house. In the presentation, you are going to see enlargements of the rear house and enlargements of the front. Again, this was taken August 13th, and right there in the middle of the parcel, you see a 20,000 square foot cultivation that the applicant actually grew last year. So, the second cause for denial was the applicant failed to meet the requirements of Section 1795-170A4, and that reads as follows. Registration of a medical cannabis cultivation site pursuant to this chapter may be invalidated by the planning director for any of the following reasons. 4 is application for registration contained false or misleading information. Pursuant to County Code Section 1795-165N3B, the registrants submitted 14 photographs as evidence of cultivation on the parcel no later than May 10th, 2016. With the exception of 1, these photographs were all dated March 28, 2016. 7 of these photographs depict dry grassland, more typical of dry conditions in the county later in the season. And what you see on the screen there is one of them. The date is March 28, 2016. You can see the dry grass in the field behind. Not pretty typical of what we can expect to see here on March 28th in the county. Again, there were a number of these in the submittal. I believe there were 7 in total that showed the dry grassland. Actually, on the hill back here, it's kind of hard to see here, but that is all as yellow as what you see right here. And again, there were a number of these in the field behind. You can see the dry
Excuse me,
grass.
would you say then the green grass that's showing there is just is a lawn?
Yeah, that's what I would say right there. And yes, that is the lawn area. And actually, if we wanted to go back to that August 20th aerial, you would see that lawn area at the house in the rear, I believe is where that's at. So going forward, again, dry grass. Now, let's look at aerials of the actual conditions that were on the ground at the time of March 28, 2016. This aerial is taken from Terra Server, and it is dated March 17, 2016. So that's 11 days before the evidence photographs. This is the front house. The planting area where those pictures were taken would be along this fence line back here where the trees are, but you can see there's green grass all over that site. At the rear of the property, again on March 17, 2016, the planting area is here in the side yard, but again there is green grass all around the site. Let's go to a date beyond the March 28th evidence photos, and that will be April 2nd of 2016. This is 4 days, I believe there's 30 days in March. No, 4 days, 5 days? Anyway, this is the front house again, and you can see that, again, the lot remains quite green. And if we go to the rear of the parcel and we look at the house in the back of the parcel, again, it looks quite green all around here. There's no evidence of that dry yellow grass that we see in the March 28th evidence photographs. The appellant, in their appeal letter of February 24th, explained that the photographs were generated from smartphone snapshots. The photographs were produced at a coffee shop where the correct date was taken from the phone and added to the photographs. The appellants explained that at no time were they being misleading with their pictures or the dates that they were taken. The land in the background had dry grass due to long-term drought conditions. Let's see here. I'll go forward a little too fast. So, what we actually see here is a failure to meet the section 1795-178-4. We do see here false and misleading information. It's false because the date stamp of March 28, 2016 on the photo does not represent the actual condition on the site as shown by the aerials of March 17th and April 2nd, 2016. It is misleading because it shows cultivation required to meet the requirements of the ordinance prior to May 10th, which was actually not occurring on March 28th at the site. And I believe that's the end of our presentation here. Does anybody have any questions?
Yes.
Go ahead.
With respect to the requirement to have a lease, in addition to 17.95, 165N2B, which you've cited, there's also 17.95.165A2R that says that the registrant has to provide a copy of a fully executed lease or a recorded deed demonstrating that the registrant had lawful possession of the parcel to be registered as a cultivation site prior to May 10th, 2016. The handwritten note would appear to me not to meet the requirements of a fully executed lease. Would you agree?
Correct. Yes, sir.
So it doesn't satisfy two different parts of the ordinance.
Correct.
Okay. Now, the staff report, I think you said 7 of the 14 photographs show dry areas.
Yes. I believe that's
Do the other 7, apart from the lawn, any of the other 7 show green grass, naturally growing green grass?
Naturally growing green grass? No, sir. I would say that it showed irrigated grass, it showed lawn areas, but I didn't see any naturally growing green grass, no, sir.
The aerials of March 17th and April 2 don't appear to show any cultivation. Is that your interpretation?
That is my interpretation. It would be hard to tell, I think it would be hard to pick out actual, plants that size from that elevation individually. I mean, it's not like we normally see a well-defined cultivation area. Those are scattered along the fence lines. But, when I look straight at the aerials, I would say I don't see any cultivation.
Do you think that there is a failure here to satisfy 17.95, 165N3, A or B? Because if you disregard the photographs with the dry grass, which do appear to be taken later, where is there any photographic evidence of cultivation or grading or earth moving commensurate with the area to be cultivated prior to May 10th? I mean, do you have that?
I can't say that we do have any evidence that is commensurate with the 22,000 square feet. No, sir, I can't say that.
All right, thank you.
That was not provided, no, sir.
The way you worded that
Go ahead.
suggests there may be other photographs we haven't seen?
Yes, there were. There were, as my staff report states, there were, how many photographs altogether submitted? There were 14 photographs submitted as cultivation on the parcel no later than May 10th. Yeah, there are other photographs you haven't seen. They're here if you'd like. They're here if you would like to see them.
Well, I would assume the appellant would show them to us if in fact it's different than what we've already talked about.
They're here if you would like to see them.
Talk about the lease for a second. I'm not sure I agree that the date, the signature date is, the discrepancy between the signature date and the commencement date of the lease. I don't think that's a discrepancy. I think you can do that. You can post or predate a lease or post date, whichever that is, and still have a valid lease. But when did you get the type, the form lease, the California residential lease agreement?
Look and see.
Did you get it before June 30th? Dated June 3rd. Right.
Bear with me here, I'm sorry. There it is, right there. Okay. Okay, there is no date stamp as far as when it was received specifically, but there is, no.
What's the application?
When I look
date?
at the application in front of me here, on the front of the application, there is a receipt date of June 30th, 2016. And when I look at the signature page, page 5 of the lease, there is a received date stamp of July 11th, 2016. So the scenario I can extrapolate from those two different dates is that this application came in on the final day. Okay, as Mr. Maurer has previously told you, we were inundated Okay, so there wasn't time for anything like a complete review. But that lease may have been looked at that time on June 30th, and at that time sent back. It's possible that the new lease came in on the July 11th date we see stamped as the receipt date on the application.
I've seen a lot of leases, I've signed leases myself, and they're very often dated, signed before the lease commences.
Right.
It's rare to find, in my personal experience, I can't remember a case where the person signed the lease and the lease started that same day. Going the other direction, I can't think of a particular reason legally why it wouldn't be okay.
One,
To
one,
predate
obs-
it.
oh, excuse me.
Yeah, no, that's all.
One observation I have as to the lease is that number 5 of the printed lease, which they've filled in the name Scott Lopez, has it exclusively using it, but it says it's shall be used and occupied solely by tenant and tenant's immediate family, consisting of Scott Lopez, there's a none there also, exclusively as a private single-family dwelling, and no part of the premises shall be used at any time during the term of this California lease agreement by tenant for the purpose of carrying on any business, profession, or trade of any kind, or for any purpose other than as a private single-family dwelling. So I will wait the applicant's explanation why this lease has any pertinence at all.
And another comment I would just like to make is, as we have seen with photographic evidence on other projects, we have seen where dates have been moved forward or invented, or whatever you would want to call it, to meet deadline obligations, specifically say a May 10th for photographic evidence. This is a deadline obligation for lawful possession of May 10th of the property. And I think that is probably our concern when it comes to predating of the leases. I know I have seen at least one other in our office. And I don't think, I'm not exactly sure that that was the intent, but I think that would be a concern of ours in regards to the predating of a lease.
On this property, there's 2 homes, correct?
Yes, ma'am.
Do both homes have the same address?
That I do not know. I cannot answer that question.
Because there is no address on this.
There is no, absolutely. That property is not identified.
Okay.
Can I ask a couple of questions?
Oh, absolutely.
Okay. The handwritten letter obviously is because you had 2 people that did not know how to put a lease together. So they thought they were meeting the terms of the urgency ordinance. At some point, they were obviously directed to the urgency ordinance and said it has to be on a valid lease. You can see where they made attempts to make it valid. The handwritten letter is not valid because it did not have a start, end date, and a monetary value. That's what invalidates the handwritten letter. But they can go back, because a lot of times, I mean, and it happens all the time where someone allows another person to move in. They don't have a written agreement. They just are going to handshake it. That's not uncommon. So my question to you is, for validation on this with an address, did the owner, the landlord, or the owner of the property give you the notarized letter that is requested in the urgency ordinance?
No, we have seen no notarized letter in relation to the leases at all.
And that wasn't documented in the resolution as not having that either, because that was one of the qualifications.
Are you seeing,
I'm saying it's not a complete application if it didn't have a notarized letter from the landlord.
are you talking about the landlord's consent? Is that the question, whether the landlord?
It says
has
it
provided-
requires a notarized letter from the landlord in the urgency ordinance.
17.95.165A2Q.
I can't say I've seen a specific notarized letter in regards to the lease. I do believe we have the standard landlord consent form.
Yeah, I believe that's what is being referred to in the code as the landowner consent form, because they created a form for that, that's notarized, whereby the landlord signs a consent form indicating that they're aware of the cannabis activity that's occurring on the property.
On other appeals that have been presented before us, they have brought in a notarized form saying that the landlord has, and I circled that, and now why am I not getting it? Kelly, what number was that again? Never mind, I got it. Okay. It was Q. If not the owners of the parcel to be registered, all registrants shall provide a letter signed, dated, and notarized by the owners of the parcel verifying that the owner was aware that the parcel was prepared for medical cannabis cultivation prior to May 10th, 2016, and the registrant continues to have permission to cultivate cannabis on the parcel. The letter shall include the name, address, and phone number of the owner. We have seen those presented to us
Right,
before.
Okay, very good. I believe what it's saying letter there, and I believe that actually refers to our standard landowner consent form, which was executed by the landowner, and it appears to be properly notarized.
Okay, and it has the address and everything on there, and it acknowledges
Yes.
that they had permission to be on that property.
That is correct.
Okay, now going back to the lease. Because they were putting something in writing that was predating trying to comply, the address is missing on the contract, but it's very evident that what they were trying to do was get you the proper document. The fact that the arrangement, they could have made the arrangements on June 3rd, which predates their June 30th registration date. That I have a little bit of an issue with. But as far as making this document, it does meet the validity test of a start, end date, and a monetary value. It's missing an address. A little bit of an issue. But if you have a notarized document from that owner backing this up, it does add some validity to this contract, right?
But it's missing the use of any commercial.
It isn't if the
haven't
owner,
seen it.
okay, if the
I've
owner,
seen this piece of paper.
correct. But if the owner notarized the document acknowledging the growing, that would supersede this.
If it has all the language in
That's
Q,
right.
it would
That's
not
right.
necessarily supersede it, but it would cover the basis
That's right.
for the lease.
So that's just, I just want to go on the record with that portion
that's all
of
good.
this. I mean, we still have the issue of the dry grass. So I'm not, but I want to make sure that we don't say that this is completely invalidated if we have all of that documentation in a notarized form that would have been presented with the lease.
Do you have it there?
Yes, I actually do have a landlord consent.
Is the address on that
The
that the
address
property
is
is being grown on?
Yes, it is 5348 Messing Road in Valley Springs or Burson. They actually wrote both of them down right there. And 5348 is the date, is the address on the registration for the cultivation area.
What date was it notarized?
It was notarized, I believe, it was June 28th of 2016.
Okay. Okay, if there's no further questions, I'd like to hear from the appellant.
Well, I do have a question.
Okay.
Really of Commissioner Wooster. What was the section you were citing as far as the completed lease?
That would be,
Q.
The 1795, 165.
1795A2R. Which,
Nine-
and
165.
that describes what they have to provide with their registration packet. You have to have a copy of a fully executed lease, et cetera,
Yeah.
demonstrating the registrant had lawful possession of the parcel to be registered prior to May 10th. And so one of the problems here is, does any of this show lawful possession prior to May 10th when it's all when the written one, the typed one is post-dated?
Well, the signature.
Lawful possession would be
But the
them
actual
in,
date was May 3rd of the commencement.
possession would be their lawful possession. If they've been in that house for 10 years, they have lawful possession of that home. So what they had to do to satisfy was recreate this. This document doesn't mean they didn't have lawful possession even before this. I mean, I don't know if you've ever tried to get a tenant out of a house, but even if they don't have a lease, good luck. They
So-
have more rights than an owner does. So the fact that this owner has signed on and signed the notarized document saying that they had possession and lawful possession, it does add some legalities to it.
Yeah, the commencement date on this form lease is May 3rd, so he's beating the May 10th date.
You can see that there were some
What'd I say?
comprehension issues on the contract, but if it's not something that you normally do, they probably should have gone out and hired someone to do it for them. I think that's why I want to hear from the appellants. I want to get some explanations. Would you guys like to come up, please? Hi.
Hi, I'm Scott Lopez. My business partner, Justin Hecker, is not here because of family issues back in Kansas City with his mother. That's the same thing. We asked for a continuance. I think Paul, I called him when this stuff was going down. I had a surgery, but his mom has some issues going on, so he's having to fly back and forth. He wasn't able to make it because of the still stuff. But I've known the landowner, Shane Cartwright, for a very long time. I've been growing there for a very long time. The thing on the deal, I've hunted up here, been growing up here in Calaveras, even though I'm living in Stockton, but I did live at that address at one time too. Had my cars registered there and stuff like that in the past. But when I moved back home with my wife, I put them back in the San Joaquin County area, that address. So they're not registered here no more. But as being I don't know I only went to school in 9th grade, so I don't know nothing about all the land leases and stuff like that. But anytime I went hunting on people's property, I got written permission. Did I always put an exact date in, start in? No. But I still have that one from Shane, which has been written for a long time. And then we didn't start doing this till, some years back, because there was an issue about maybe me coming up, and if I got coming in, neighbors calling the cops, and the cops came, I could just show the cop this, give him Shane's number, and this would keep me maybe from going to jail and getting ran in or anything like that, instead of getting handcuffed and all that. But anyway, we went to fix that date, which I told Paul that, this was a typo when I came here about a month ago, was it? Right before I asked for the continuance. Remember I came and talked to you in office?
Yeah, I remember us.
And I told you about the lady that she said when we were all sitting, and I think it was that room next door, that they were a new hire and they crammed everything to get them to learn how to do everything, trained. They crammed in like, I think maybe 2 weeks, she said, but a week to 2 weeks. I don't know, I'm not there is it. But here's your handwritten little sticky things that was on the deal that I had another lady in there, kind of curly short hair maybe. I don't know if her name was Sandra, but I asked her, I came in to give this to you, but somehow, and then she started to circle stuff and cross out. I said, oh no, don't do that. Don't cross stuff out. But anyway, she put it on that paper there, and then for some reason, we forgot to get this copied and handed to you, because I have been working and everything with you.
I don't recall seeing that.
Can you read that?
Well, no,
note?
you didn't, because I brought it back up to you after I told you. Remember we had our little discussion when I first came and seen you, and I said, oh, I got handwritten stuff.
I'm sorry, you need to address the commission and not Paul directly. And
Okay.
can you read that little handwritten note out loud?
Okay, this is part on the lease that says, because she wouldn't accept my lease, not because of dates or anything. Her words were, it doesn't look professional enough to me. But she still took it.
Can you read her hand? She had to take it.
It says, wherever it says landowner has to sign. Lease prior to 5/10/16, plot, PBT plan, old and new Colt, no bigger than or it's 11 by 17 or something like that. But I mean, you guys could take a look. This is her handwriting. I have a couple
Okay.
other little sticky deals that's in her handwriting. And
So
if I seen the lady, I could show you her.
So you do not have possession of the property physically, you don't live there?
No, no.
No.
I've been growing there forever. I mean, for a long time. And I do have proof of that because we didn't take pictures. For one, why would you take pictures of something on the federal level that would get you locked up or indicted and face a criminal trial?
No, not if you were growing under 215.
No, still under the federal level, you could be arrested. Medical, under California and under county or city law, it's still legal. But at the federal, if an ATF agent lived next door to me and he seen my plan, he would have to do something. He swore to do it because on the federal level, it is not legal, not one bit.
Okay, all right. So under the registration,
Yes.
it's still not federally legal if you want to go there. We won't go there.
Well, no, I know. So that's why we.
Okay, but under that registration, you signed an application and agreed to the terms of the urgency ordinance that was being put forth, right?
Yes, ma'am.
And you had a list of items to follow.
And I did them to the best of my ability.
Okay, and one of those items was photographic evidence that you have been growing on that property over the years, correct?
Yeah.
Okay. The photos that you submitted show brown grass
Okay.
in March or April.
I was. It
And
showed.
typically in March or April, we're pretty green in our hills.
Oh, I know it.
okay.
I can explain that.
Okay, well, that's what we want to hear from you.
Okay, so when I brought in, not only she wouldn't accept this, but was able to give her a copy and have her put it in there, but she would not accept this because it wasn't professional enough.
Well, it's not a valid lease, that's why.
Them are the wrong dates. These babies right there, them babies right there are actually these babies because she wouldn't accept my photos at all because the 300 babies were in a garage. And she goes, I have no land reference. And I said, what do you mean? You can go there right now. There's all the motorcycles. There's the floor. There's a stack of tires. They're still in the garage. They're still there today. At the break time, I thought I better go take a picture of this garage with all the motorcycles, the stack of tires. And here's the picture.
Okay, so if she did not accept the photos that you were trying to submit of your babies in the garage, how did we end up with photos that are dated for April with brown grass?
That was a mess up. That was a mess up, just like this thing right here, because now we're talking June 30th. It's the last day. I have to leave here after waiting. If you guys remember how big that line was, I got in late. I had to run back all the way down to Burson, take some more pictures of the babies. Now, in the pictures you're looking in there, they're a lot bigger than the smart pots. But if you look right here with the garage pictures, these are in little tiny pots and they're a lot smaller plants. Them right there are these ones in March.
Okay, time out 1 second. Is this a mixed grow or outdoor?
It's outdoor, I believe.
Okay,
Yeah, it's mixed lighting.
it is mixed light?
Yeah, outdoor
Okay.
grow.
Okay. These photos with the brown grass, when were those actually taken?
June 30th. That's what should have been put on there.
Okay, so who put that date on there and who printed those?
The printing company did. And we thought we told them right, and we didn't. We didn't, evidently, from my business partner.
What printing company? On
The-
June 30th, what printing company did that?
The one right down here, right down in town. Right down in town, ma'am. I didn't have time to go anywhere else.
So
I had
you
to-
tried to submit the photos that you have there that are properly dated
Yes, I did.
When?
on June 30th?
On June 30th, and she wouldn't accept them, and I only got one day. I had to do a frantic run.
Can you do me a favor?
Yes,
Can you
ma'am.
pass a couple of those photos over to Annette so that she can send them around to us, please?
Yeah.
Paul actually has those photos.
I believe we do have those photographs in our file.
Yeah, I didn't see them up there, though.
No, you didn't see them up there. As I said, there were other photographs, and These are some of the other photographs, and
Are
yes,
they
they were
date stamped?
submitted. And they are date stamped March 28th.
March 28th.
Like the majority of them are, with the exception of one, which I believe was in June or July and showed a truck. Anyway, after you pass those around, we'd be glad to see these.
It's a ranch that got all kinds of trucks, everything.
The one that was stamped otherwise is this one here from, its date stamped June 25th, 2015. It shows dry yellow grass.
And when I came in a month ago, I tried to explain some of this stuff about the lady and everything. And Paul was nice and decent, but it was just basically, there's nothing we can do now. We'll see you at the appeal. And he was kind, and I was kind, and both respectful to each other. And I tried to talk a little more, thinking maybe we get, but he just stopped me again and said, well, like I said, there's nothing we can do. It's already going to the planning commission. So I couldn't go through the whole story. It's
Okay.
basically, we're done. Tell it to the board.
We have a couple of really big issues here.
Oh, I know it.
June 30th was the deadline. And
Could I hand this up to you guys too?
certainly, I think we probably already have that.
And in the date, it shows the July, whatever, but that was a typo. We're hurrying. When she told me that when she told me that the
I'm
lease
sorry,
wasn't
I'm sorry,
professional enough,
who is she?
the lady that you guys hired to take our packets in on June 30th. She was a blonde-haired lady, probably about, I want to say 30 to 40, say 2 years old. But I mean, if we brought them in, I could show you her. She said she was one of the new hires that they hired, like I said, to do that. And I think, was Lopez a new hire too? There was 4 of them hired, I think. She was saying there was 4 of them that got hired to take
Okay,
these
and
applications.
what is the issue with the piece of paper you have in your hand?
It was just a mess up. That the dates are wrong. So Shane has signed it, initialed it, dated it, and fixed it. We did notarize our deal. Thank God, because I didn't copy that. You guys got my original thing, I think, because I can't find my notarization, but I knew I did it. And I got this. Here's this. Here's the fix, the typo that got fixed, because it was a mistake. It was the wrong date. It should have been dated the same day as the babies on the pictures, or therefore something like that, September or March 30th, whatever.
Okay,
March 30th.
do you see how big the issues are here before us?
Oh, yeah.
We
but-
do not have a valid lease. You do not have possession or occupy the property. All you're doing is growing on the property. When June 30th came and you submitted all these documents, it was not a complete application. June 30th was the last day to submit. It appears that they gave you a opportunity to bring back a valid lease, and it still had errors in it. We had photos that were submitted with wrong dates on it, which is considered misleading under the urgency ordinance.
When did they give me time to bring back a lease? Because I had to,
Well, apparently you didn't bring it back until later because you didn't have it on June 30th. You had a handwritten letter and you read us a note that said you need to get that fixed.
on June 30th, that was only because it wasn't a legal thing. On June 30th, I went down to that printing store. They have them. That's what she gave me, and we actually put the wrong date. So June 30th, that was sent in, but it shouldn't have said June 30th. It should have said on the March 3rd.
She said March 3rd?
March or September.
Say
I've been
It
there
says
and
May
read,
on there.
It's May.
It's,
or May 30th. That's it. It's the 3rd.
So when you left
May.
here June 30th, you
Yeah.
took those notes, you went to the San Andreas print shop, you had them
May.
print more pictures. May.
No, I'm just
June
looking at-
30th, you came in on the last day of registration.
Yes, sir. Yes, ma'am.
You got a note saying you have to correct these items. You went to the print shop, printed new photos, got a lease, and brought it all back? You filled this out on the
And I
fly?
thought, I filled it out on the fly, and if I think that's right, Justin was filling that out because, I wasn't sure, I haven't filled out very many forms, and I was all nervous.
So, okay, so let's just back up one more second here. How did the owner sign this on June 30th? if you were doing this on the fly?
He was there. He was at home.
At home?
Yeah. He signed this one, yes.
No, but how did he sign this one?
He was at home. Shit, I remember I told you I flew back down
Oh,
to the
okay, so
property.
you went back to the property for him to sign this?
Yeah.
And take pictures.
I only had a little bit of time too because it had to be quick. Everything had to be quick. That's why the dates got messed up on that. Wrong dates got put in the wrong spot. But if you look,
Is that the date you took those pictures?
huh?
Is that the date you took those pictures? You went back to the property, did you take those pictures on June 30th?
That's the date I took them pictures, trying to show that in the garage, and on March, was it, in the garage? In the garage is the pictures of them babies, a lot smaller in smaller pots. You can't put them out in the middle of winter because cannabis won't live in that cold. They'll die. I've been growing pot for 27 years. I know what it'll do if you leave them outside in that time. And that weather right there, they're gonna die
So
overnight.
you took those pictures June 30th and then had them dated March 28th?
Yeah, but that was a mess up. They shouldn't have been that date. The girl messed up putting that date on them.
Now, those pictures, the pictures that show them out like that, do you agree with the planning department that those pictures were taken in the garden of the houses, of the two houses? In other words, right near the actual dwellings that are on this property?
Say that again?
The planning department has presented us these pictures, the pictures that you apparently took on June 30th, and they have said that the area where those pictures were taken was around the house.
Of the front.
Yeah, they're in the back of the house, the front
On
house.
the side of the rear house.
Yes, they're both right there underneath the trees.
But they eventually they were planted in the ground or in pots?
Smart pots. They stayed in the smart pots, and then when we got the go-ahead, when we finally got the go-ahead and they said, go ahead and go to work, then we took them up there and we cut the bags open thinking because I didn't finally get in till when they finally gave me my thing to say go to work. I think it was almost towards the end of July.
Who's they saying go to work?
The planning commission,
Planning department?
the planning department, or, yeah.
I've never heard that the planning department gives a green
Okay,
light to go ahead.
When we paid our $5,000 after they accepted our packet and telling us everything looked good, even the dates that you got on the typo one that got messed up, even accepting it when at first they wouldn't accept nothing, but when we came back, then they accepted it. They said, go to work.
Okay, on June 30th, they accepted everybody's documentation and said they would get back to you because it was, as you know, the line was long and they had no time to sit there and review and review and review and review. So you were lucky that you got that note and got an opportunity to go back out and try and bring
No,
it in.
yes, ma'am. And
But them accepting it did not mean it was an accepted registration. It just meant we've taken your packet and we'll review it.
no,
later.
yes,
Okay,
ma'am, I understand
okay.
that. But at first, I didn't get accepted. I was told, no, they weren't going to accept my pictures. They weren't going to accept my unprofessional lease. And I had to go do this, you see, and then I had to come back. And then I had to jump through the hoop to get it accepted.
Why were you submitting pictures in the dry grass? What was the point of those? Oh, that was because...
But it's because everybody was up here telling me we had to have documents. We had to have
Okay.
picture step
Okay.
documents.
Okay, so do you have anything different or further to add at this point?
Yeah, I got a handwritten note from the front house, which is Jean, right there that she gave me previous years to grow. And the Google map that he's got, where I showed him when we had our talk over there, that if you look in April of 2013, it's clear ground. A couple months later, there's bushes and trees. I showed him that. He said, "Oh, I can't tell. I can't see that." Well, he's like he said, he's taking aerial photos. But in a couple months, how can you go from bare ground to big giant, shrubs?
Did you say you have a letter from somebody else who lives in the front house?
Yes. You need this?
Please.
Yeah, I'd like to see.
So,
As Penn State, I've been growing there years past. I also do, what'd I do with it? Have this, because like I told her, the lady way back when on June 30th, that we don't really take pictures. We got probably just a couple pictures in all the years I've been growing there, ma'am, board. Maybe a couple. There is a hard drive right now in New York City at a recovery place that it's gonna cost me $2,000 to fix the hard drive out of the computer, and another week or two before it comes back. I have the email on my phone from the guy and the company. They do extractions for the government, police, homicide, cases, all like that. They're doing my thing right now because anybody local couldn't do it because they weren't big enough or
What are you extracting?
more pictures that I grew there in the past that we've been growing there that's got dates on them off the computer.
I thought you didn't take pictures because of the federal government.
I didn't. Shane, though, however, there's 2 pictures on this one off his hard drive. The computer, he says he thinks he's got 1 or 2 more. Me, myself, I didn't like to take pictures at all. And if I did, I'd delete them immediately. For one, I don't need my kids seeing them. Don't need that stuff laying around. I don't need to be questioned. We're already, if you guys know, they're already black thumbing us, a black stain, because we're marijuana cultivators, medical marijuana. Even if you say medical, there's a lot of people that don't believe it, don't like it, and they look at you different.
Did you just say you don't want it around your kids?
What was that, ma'am?
Did you just state you didn't want it around your kids? You didn't want your kids to see it?
I didn't want pictures of just seeing it. That's something, when do they go to school? And they say, my dad's got pictures of marijuana. Then you got cops coming to you. Even though we're legal and we got prescriptions and we got everything, it's like I just said, you're looked at a black stain by a lot of the people, by a lot of the community.
It doesn't matter.
Well, no, it does matter.
Well,
That's why we
well, I
won't
just
have
understood
pictures.
you
No,
saying
due to pertaining
it
pictures.
offended me, so I just wanted you to reiterate it, because it's okay for your kids not to see it, but it's okay for the kids that live in Calaveras County to see it?
I didn't have them out around it. There's no kids around
just
my property
stating-
that did see it.
And who is Gene King?
What?
Who is Gene King?
Put the name on.
That's the mother in the first house. That's the tenant in the first house. She's been living there ever since the land was purchased by Shane.
So
That's
does
Shane's
she own
mother.
the property, or she just leases it?
No, she's a half owner of that property. That's all one address. They couldn't split that property up when Shane built the new house out back, right? So they got one address for both houses. It's on 10 acres. They couldn't split up the property, and that's the way it is. They get their mail, one mailbox, same address for both houses.
Now, I want to see if I can summarize your position, okay? And tell me if I've got something wrong. That you had the pictures showing the plants in the garage when you showed up here on June 30th. Apparently, she did take them because we ended up with them in the file, but she said these aren't good enough? Is that basically?
Yes,
have
yes,
I
sir. That's
got this so
exactly-
far? And then,
Matter
so
of fact-
and she didn't like the lease, even though a copy ended up in the file.
She wouldn't accept them, and even when I came back,
Now, just a sec, though. I'm going to try and make sure I've got the train of thought here. And so you raced on down to the property, took the pictures of that we have in evidence here that have been shown up on the safe. And those pictures, then you had copied in San Andreas, and somehow the date 3/28 ended up on them. Is that, have I
yeah,
got this right?
yeah, I don't know, if, like
You-
Justin told them to write them or,
And you brought them back and I guess got back in line or whatever.
yeah, we had to get back in line.
And submitted those along with the formal form of the lease.
Yes, sir.
But that lease, in the rush, it got the wrong date written on it. It should have been May 3rd
Yeah, on
instead
the
of
new,
June 3rd.
on the more professional looking one.
Right, okay.
Yeah, that wrong date's got on that.
So I've got.
You got it kind of right,
Got
yeah.
it? Okay, thank you.
And then, what else was there?
Well, one other question I had. Now, if the eventual, where you plant, or either planted the plants, or where your initial grow, or your final grow for last year was kind of in that square that's in the middle of that picture? Is it around that area?
Yeah, that's where it kind of, maybe a little bit more down in this way, but you couldn't say about dead. Because then they said you couldn't grow next to the property line. You know, that took us away from our cover.
I see,
And the other property line's over here on this side of the house.
I see.
So to stay out of the, what was it, 75 feet? We had to move it to the very middle. Because over here, we thought we were in the 75 feet, within the 75 feet. And up there, we were growing right on the,
Yeah.
always on the fence
So
line
you
and behind the,
you were intending to grow where these pictures
well, we
were
always
taken?
were able to grow.
I see.
So on the pictures, like these pictures, Paul, these pots showed they close to the house. So you moved the grow?
We moved the grow after we found out we could not grow next to a property line. Any kind of boundary. If you gotta be 75 feet away, isn't it, Paul?
Yes, sir.
Yeah, so we had to move that, back to the middle, back to the very middle, and we couldn't be stretched out underneath the trees no more. If you see in the back of the house, it goes out like that, and over here it goes like that.
Okay.
Okay.
So we're kind of running out of time for you on this because, we need to move it forward. We're repeating the same information over and over again. Are there any new questions or new information?
Yeah, new information is I wanted to show you the prior dates, the prior pictures, like in, on Google Map that I showed Paul, were in, April of, April 4/13, that, behind the first house, it's bare land. I tried to show Paul this, and I said, you go to 8/13, and that bare land is now full of bushes. Some of them were trees, some of them were 9 foot tall now. I want to know, I asked Paul, what grows that fast in just a couple of months? Cannabis, because we're watering it, we're giving it fertilizer.
Okay, we'll take a look at your photos, and then while they're being passed down, if you could hand those to Annette, please.
Yeah, these ones are not as good as actually Paul got, because I didn't take copy, but I took these ones off Google Earth, one's on a Polaroid, and one's on this. But I mean, I could point out exactly, like if you got the one, the Google Map one I tried to show you, when you brought that packet out to me and we were looking at it.
I
I'm
don't
look-
recall you having any photographs you were trying to show me.
The Google Map one that you pulled out of the packet and I showed you right there.
Let's see where it is here.
When I'm looking at that
It's
area.
not on there.
It's not, okay, it's not in the presentation.
I think it's still in the packet.
I don't believe you provided us Google. Let me just look.
I provided it to you guys and you showed me when we had our talk up there and I showed you on that packet.
Well, are you talking about this?
The Google Map, and you told me I can't tell that's cannabis. Well, it's from the air.
Are you talking,
Where's your fencing?
But if I can point out to one of you,
okay, I remember that. And yes, I remember telling you, yes, I could not tell, no.
but you could see the clear spot, and then all of a sudden where stuff grew, you just couldn't see what was growing. But in a couple of months, it went from bare to big green stuff.
It was quite a small little area as represented by the photographs that you submitted. There's no way I would see that near.
Can I look
So
at it?
I think that
You can.
he's asking that be submitted to the planning commission.
You understand what you're looking at. I cannot identify that as cannabis.
Okay, there should be two,
Okay,
right?
okay, so we're getting back off track
These are a
here.
lot better pictures.
Okay, great, but we're off track here again. You're addressing the commission, and Paul's addressing the commission. You don't get to interact and play.
Okay, I'm sorry.
Let's bring it back, because we're getting kind of out of control on this one.
Also,
I
if
like
anybody needs a transcript and everybody's talking over each other, it will never get transcribed properly. Your
Okay, I'm
voice will
sorry.
not be on the record.
I've got one question. This California residential lease agreement, the typewritten one, was that actually signed on June 30?
The professional one? Yes, it was. Because all I ever had was this. And I have
Okay.
ones for going hunting up in properties in West Point and everywhere. And there's not actually today on June 1st, 2017, I give Scott permission. It just says, the name, Cora Thies, give Scott permission to hunt on my property at the address.
Okay, I understand that
And-
doesn't have any relative documentation for this appeal here today. The one that does is the one that you submitted that was not a valid lease. It was a handwritten note.
Say that again, ma'am?
It was a handwritten note. And then you went to go get your professional one, when you scrambled around, the one you returned did not have a date that was proper on it. It also did not have an address to identify the property that you supposedly had possession of.
Yeah, even the handwritten thing right here said, put a start date and end date on it. From the planning commission was the girl that took my packet.
We're not doubting that you got that note. We're not doubting that you scrambled around, that you went and did all the things you said. I'm good with all that.
Okay.
That you're okay with. But we still have issues with, and you're submitting more documentation and photos that came down the line here. We still have the issue of that the lease, I don't even know what direction to take this in, because the lease technically is not a valid lease.
But I thought,
You did go out and get one, but there's no address on it telling us that you had the right to rent that address. The only thing you did have is the notarized document.
and that supersedes that, you said, didn't you?
I said it would back it up. It
Oh, I
does.
thought you actually said supersede, and
I may have used that word.
yes, that's what I heard, and
It can't
We've been-
supersede the lease, because the notarized document doesn't have a start, end date, and an address, and a monetary value. Your lease has that. You've got a lot of missing components and a lot of misleading information here in front of us. That's what we're struggling with. You know, when you run out and take photos of June 30th, and that's what you submit with an inaccurate date, what that does for us is say he was trying to mislead us. And then when you give us the other components of your story of that was being grown in the garage, for me, the question here for today is, why would they have denied the baby plants in the garage photos?
her words were exactly, there is no reference point. And I said, what do you mean there's no, if you went to the garage right now, at that address, these motorcycles, these stacks of tires are all there. I got my phone where I went there right now with the location deal on it. The motorcycles are still there, the stacks of tires are still there, the seam on the floor is still there. Paul can come out, anybody can come out, I'll show them today, tomorrow, whenever. Show them exactly where, with the photos, the reference points. She would not take them because there was no reference. She couldn't look at something and say, so that's what she told me, is that I can't say, oh yeah, this was grown out here next to this field. Well, we're not going to put babies out there that cost $1,100 for every 100.
Do you have a
We're not
copy?
going to put them out there.
Do you have a copy of this, the actual signature page of your lease?
I think they got it.
My question to you is, you told us that you went to the print shop and got this on the 30th, and you ran to the landlord's house and got him to sign it on
Is-
June
is-
30th. You said you did this the day of the application, correct?
Yes.
Okay, I think that is the original. And here is the copy.
Okay, so
Which one
you-
is it?
that's the same
This
page.
one?
So you told us that
Come
you
back
went
behind the
and you got
podium,
this on the
please.
30th, correct?
I can't see.
I know.
Well, no,
Hand-
but if you look at it, it's the same one. So if you look at it, you told us you went and got this on the 30th. But you dated everything June 3rd, that you said that on this paper, misleading evidence was,
That's because we filled it out wrong.
Can you please step back to the
We got
podium?
the dates mixed up.
Mr. Lopez, back to the podium.
Oh, yeah, sorry about that.
Thank you.
That's because,
it's just another sign of misleading evidence.
no, it was maybe that a novice guy that don't really know what he's doing, 'cause- and putting the wrong dates on there, but not that. I've been growing there for years. I got things right here that, probably only one of the only two pictures that we know
I'm just trying to
of.
point out to you that you printed the pictures and you put a misleading date on it. You put on a date that was not accurate. You told us that you went and you got this on June 30th and that you took it to the landlord and you both signed it on June 30th, but you dated it June 3rd. That's another misleading evidence that you turned in.
It wasn't supposed to be misleading. The dates and even the correction was on there with all our initials. The letter tells you I grown there in years past. Pictures with documents of years past are right here on this. I thought I had everything right. I'm getting told nothing's right. I'm on the last day. Is it not human to mess up on some dates? Filling stuff out before I only had a little bit to get in. I waited almost all day. I got in the
Can I
afternoon.
ask a
Now I'm
question?
having to drive way
Yes,
back
can
and
you,
forth.
can you hold on for just a moment, please?
I have a different topic I want to talk about briefly on the photos. And Mr. Groves, if you could help with this. Are there any photos
Paul's
of
not listening.
your plants that show the final location where they were actually grown? And consistent with what your application said, where they would be located?
Is there any pictures of the area that's fenced in now? I don't know if we had any
In
there.
other words, it's the commensurate language. Do we have proof of the commensurate language?
We don't have, no, we don't have proof necessarily of commensurate. We have,
So his application was for a different part of the parcel.
it was for the areas along, the area along, let me go find this. Let's go back.
Yeah, those. Any of those shots with the pots?
Those pots were those shots of the pots, the evidence that was submitted was those photographs were taken along the fence line at the rear of this house and also along the fence line at the side of this house, right there.
And
None
the
of those were taken out in the grow area.
And the application shows where they'd be located. Does the
No.
application specify where they would be located on the
They
parcel?
specify, I believe the plot plan actually specifies a 20,000, 22,000 square foot.
It doesn't, does it show
Yeah.
that middle of the parcel section? Is that where they were supposed to be?
That's where the grow was to occur. I believe that's what the site plan they submitted showed. And now I'm just working from memory because I don't have
Oh,
the
well, I
files
see.
in front of me.
Yes, sir.
How did you know the answer? 'Cause
We-
it's not in front of you.
We did put in a thing where they were gonna be moved to and growed with the planning commission.
Okay.
Well, following up on Commissioner Baselli's question,
Yes, sir.
if you look at all the photos of the baby plants,
The baby plants, yes.
do they add up to a grow of 22,000 square feet when they're fully grown?
In my opinion, no. I can't say that they do. It doesn't look, they are small plants, a number of small plants. But it's not like you see 1,000 square feet of solid, small plants that could be transplanted into, say, a 20,000 square foot grow. That is not what you see in those photographs.
Okay, so disregarding the photos that show the dry grass, because we know they were taken June 30,
Correct?
the only photographic evidence of cultivation we have is of the baby plants, is that correct?
Yes, sir.
And the baby plants, as you add them up, won't make 22,000 square feet when they're grown.
No, I would say they wouldn't make 22,000. That's my opinion.
What would you
No,
say, Mr.?
No, there was more plants in there, but you gotta have, where I'm using a garage and there's a walkway. You put 300 plants, you're not gonna get them all, you're not gonna all get them. I took the pictures right there of them ones, right there. No, we had 22,000 square feet. We lost a lot of them after moving them and them dying from bugs and all that, but I think we arranged that the 300 were gonna be like at a 6'6" or 6'3", I might even, or 2, for the square footage. And then, but no, I had introduced receipts of all my stuff over $10,000. I don't know if they got it, but they got my receipts. I don't even have them. So there's a lot of things in there that when we left my business partnership, we should have got copies of everything. Well, we didn't, for one, we didn't have time and we were running. Last day. Had to leave and come back. It was kind of scatterbrained, kind of hectic.
Well, it's too bad you waited till the last day, because if you hadn't, you would have been able to be a lot more prepared for this.
Well, yeah. And
Because there was, 7 weeks of time to get it in. Okay, so unless anybody has something new, I'd like to close the hearing and go to public comment.
on one thing, I would like to show you guys on that Google map, because I don't know if you guys were able to actually see.
We've seen exactly what you were talking
The bare
about.
spot and then the green stuff.
No, I seen 2 green spots. One
No.
was a little more bushier than the other.
Okay, I would like to look at them again. if that
Okay, you
would-
can look at them again, because we're going to have you sit down and we're going to take public comment now.
You
Okay.
have his copies, don't you? Do you have further copies with you of those Google Maps?
Yes, I do,
I
but
have
they
them
didn't-
here and I can pass them around. In fact,
I would like to actually circle and show you because it's really, if you know what you're looking at and right where you're looking at, you'll see that it's plain. and
Okay,
then
we're
in
going
the-
to send them back over to you to do that. Okay, we're going to send them to Paul to you.
Okay.
Since there's been some question as far as the full contingent of pictures, I'd just like to pass around all the pictures that were submitted, just so, to enter that into the record so that you guys have a chance to look at that and see everything that we had.
Okay. And would you like this for the pictures in the past? 2012, 2015,
I don't think we need.
or not 15, but 13?
Oh. Okay, so when I'm looking at the baby plant pictures, at first I thought there was a lot of greenery around it, which there is, because it's on a grass area that is being watered.
Correct.
Okay, but then when you pull back on one of those photos, you can see that it's completely dead in front of them. So the baby plants are on dead grass areas. They're not on green. I was almost fooled for a second. Okay, did you circle that for us?
No, I thought we had to do it when he asked for comments.
Oh, no, we're gonna let you come up and circle that for us. So I want you to at least get all your information in. I don't want to cut you short. I
Okay.
just don't want to keep repeating the same arguments.
I just handed you the...
I thought you just took them back and said, wait till.
No, I did not take them back. They are in your package. You took them back to your seats, sir.
I just didn't want to mess up. On the other side? Sorry about that, you guys.
Oh, it's green, and when you pull back, those plants are the same size in the dead grass.
Okay.
This is all we have on the garage.
Basically, all around in here. And then is this the April? No, that's the June, but you can, is that a little more closer up? But it's more blurrier. And you can see in there, and on here. And then you can see clear in here, the winter, more colder weather, all clear in here. Oh, no, that's the new, that's the...
Okay, so the commissioners are the ones that need to see what you're talking about?
Okay, yes, ma'am.
Okay.
And that's the clear, that's 4. The ones that are clear in the winter.
You've circled on 4 of these. This
Yeah,
one doesn't
that's the,
apply.
yeah, that one don't apply. That's the planning commission one where we moved it to.
I do have one other question. Are these pictures, which ones were taken on the actual date that's stamped on it? Just the ones in the garage?
Yeah, the
Just
ones in the garage. And I got pictures on my phone that I took to show you the garage.
Yeah,
on
no,
that
no, I understand that, but the other pictures that you have here, including some baby plants outdoors, were taken on June 30th?
Yeah, they're bigger. They're, they're a few months older.
So
They're
it's
in
just-
bigger pots.
Just the garage pictures were taken on the date that's on there?
Yeah.
Does this correspond with the plot map that was submitted?
As far as the location
Yes.
of the plants,
Yes.
I believe so, but I'm working from memory as to when the...
So these are actually just copies here.
And if,
I can start one down.
and if I knew I had pictures that were even older that existed, I would have submitted them.
Yeah.
But
Yeah, we're really looking at what was
No, he said
happening
these
in.
were-
Yeah, we had to
spring.
really dig just to, a computer hard drive out of an old computer that he had put up because it stopped working. I got even the email of me sending it to that big company.
You have that email with you?
Yes, ma'am.
In answer to your question is, do the locations, do they match what's shown on the site plan? There were 2 grow areas, one matches, the other one, I would say, doesn't match. Rather than being along the fence line here, the site plan's actually showing a location over here, which obviously is not true, but we see a lot of variations in these.
Okay, but he had to move it because of the property line.
Correct.
Okay, so I can't even go by that.
Right. Well, no, they're not.
So is your position that he did not submit any photos prior to June 30th
4, 2, and 8.
that shows the growing before May 10th commensurate with the location on the application?
If you're asking me whether I believe any of those,
Any, yes.
I would say no.
None of them.
Look at these.
Really hard to figure.
It is hard to figure out, because when you look at the ones on the interiors, the interior shots,
These are the ones.
it is very difficult.
Here's the ones in the cups. Here's the ones.
I can't say without a shadow of doubt that every one of those is absolutely false.
You can tell that it was.
But I can say the ones that
The way I
we
get it,
filed
This is
the
the only one
complaint
that's got the
on,
correct date.
But this
those
isn't the right picture. I mean, he's
appear-
not.
Now, there was no digging or grading required on this, right? So it's just a matter of putting pots on the ground.
These are the same plant.
They're flat, it's a
Here's the
flat
black
parcel.
Here's the red pot.
I don't know whether
But
grading
these ones
occurred out there. You would have to ask them what, from the aerial
Because you
evidence
can
and from the
see
photographic
the-
evidence that they
sorry.
submitted.
The commissioner
I would
says,
say that we can't determine
can you
that
turn your
actually
mic off so we
grading
can hear
occurred
him?
out
Thanks.
there.
So the only evidence of cultivation that is possible would be pictures of the plants in the pots.
That is correct. There was no evidence photos that showed any grading. We didn't have any aerial evidence that showed.
And how tight are we in interpreting this commensurate language? How close do they have to be?
Well, I think I would,
I've seen
Leave
some
that.
extreme examples in some of the cases we've had where they were 100 yards away from each other, but this seems to be, some of the pots are in the right place, not many, but some.
Well, in this case, I think what he tried to show was the growing area that he had previously grown in. Had taken the photos after the date, obviously. And with the intent to move them to the center of the property, that sort of, that square area on the aerial image there. Whether, one of the questions is, was it really commensurate with 22,000 square feet? It was very hard for us to tell based on what was provided to us. And yes, we're sticklers about that. If someone applied for 22,000 square feet, they need to show us that they had previously grown or had prepared the site for 22,000 square feet. If they only had 5,000 square feet previously and they were expanding that grow area, that would not comply.
on August 13th, 2016, I don't see a grow there. I don't see a fence there. So that's where I'm struggling right
On
now.
what date, ma'am?
That date, August 13th, 2016. I do not see a grow. I do not see fencing. All the photos that you have submitted have been inside of a garage or outside next to the tree line, and you argued the point that you moved it based on you were next to the property line. But when I look in the center, the point that you're trying to tell us that the grow was moved to, by August, it should have been there, right?
No, we had to get I had the land surveyed. I had the land surveyed, then I had to get up the fence, the grow wasn't in there yet, they were still in the pots back. I didn't get the, 2016, wait, is that, can you blow that up anymore?
No, I can't blow that up anymore.
Do you have a current photo of what it looked like at the end of your grow?
I do have photos, but they are not, for the end of my grow, I do have photos, but they're on my laptop. I didn't think I was gonna be having to show the end of my grow.
Well, I want to know if you really moved your grow. Did you move it?
Yes, I moved it, they came out and inspected. I forget what girl, she came out, seen all my permits, seen my grow area. There was still some plants that were.
Do you know when she came?
It was about maybe 3 weeks to a month. I'm sure it's in there because she told me I passed everything. And then a couple weeks later, I got a letter from him.
Yeah.
I met them there I met her, she was with another guy, her and another guy, and I think I might have her phone number with her name on it in my phone, and with 3 CHP, 2 CHP.
Okay. When did you move the grow?
I moved the grow, let's see, June, I got a thing in July. I want to say the fence, all that was probably in the late part of August when we got in the ground. I would have to check my pictures and I could go home and come right back and give them to you with it in there. But probably the late June, something like that.
You moved it in late June?
Yeah, I didn't get the okay in the letter till everything, they mailed that packet back to me. And I didn't have a permit to actually do anything till almost the end of July.
Nobody has a permit to do anything. Well, you've got a registration.
Okay, a registration. I'm
And-
sorry, I keep calling it a permit. I know, I bet a lot of us do that.
Okay,
because-
but if you moved it in June, why isn't it in the picture of August?
It is there.
It is there?
Okay.
Yeah, that's,
May I
Go
s-
ahead.
The grow is actually, you see this square right here?
Yes.
Right there?
That's
That
it.
is your grow area, okay? That is what they developed right there, and it's roughly 20,000 square feet. You can see the road, the activity that occurred around that, probably activity in terms of, getting materials and plants to the cultivation area. So there was an actual grow that occurred right there in the middle of the site. Now, as far as when he was granted his registration pending, it's in the file, and that was granted, I believe, on July 11th for his,
That was after an inspection had been out there.
yeah, and that sounds right. That's
no,
about.
sir, that would have not been after inspection. This was after he was called back to the office to review his registration. At that point, I believe we took the registrant's fees and issued the registration pending application. And that's when it was done on July 7th. That's when he was called to return.
Okay.
That sounds a little more accurate, because I remember when we got the final thing in July, okay, it was like the end of July when we finally got the fence, and then we started putting the plumbing from the well 400 feet over to it, the water tanks. So, yeah, that sounds a little more, it was like the end of July though when I got
Okay.
the babies in the ground.
All right. Yeah, they're there. They're testifying to the fact they're there,
Apparently,
staff
the
is.
plants
All
are in
right.
that picture, but they don't show up very well.
It doesn't show up very well, and if there may not have been an actual fence around this at that point in time. Fences generally cast a shadow. It may be the angle that the aerial image is taken at, but that is an actual cultivation area that they developed there in the middle of the
Okay.
parcel.
Ma'am, can I add something? Just north to that square on the right side, you see like a little garage right there, a little shed?
Yes.
The babies could have been moved to there, like 300 of them. They may not be there, they may be there, I don't know how it went, but I did move them eventually, right before we got to put them in the ground, out of the shade so they could start adapting to the sun, because if you move them too quick, you're gonna burn them up, they're gonna die.
Right. Okay.
I got one question finally.
Yes, sir.
Of these, I have the 14 pictures here, and I have one photo that shows motorbikes and tires and some plants in pots, and was that taken in the garage?
Yes, yes, sir.
And of all these pictures, that bears the date 3/28/16. Is this the only one that was taken on that date? And the rest were taken June 30?
Yes.
Okay, thank you.
That I can find right now. That, you know, I've been looking at some of the phones, ain't even around no more. So,
I'm just talking about the 14 that were submitted.
yeah.
Okay, I think that,
But what I was saying is I've been trying to find more and more pictures, not of the last year, before, and years past of all
okay.
this.
All right, I think we're done and we'll go to public comment if you're good with that.
Thank you.
Thank you.
Thank you, everyone.
You're not done. You don't get to leave yet in case we have more questions after the public.
Okay.
Okay. Does anybody have any public comment? Wow, okay.
Oh, I forgot to show you that. I'll wait until that.
Okay.
Big email from the extraction company.
Okay, you hold on to that, okay?
Yes.
Because I'm going to make a suggestion regarding that email. Actually, what I want you to do is forward that to Paul at the planning department to go in your file,
Yes, ma'am.
because I want it documented for today.
Yes, ma'am.
Okay. So, we have a resolution before us to talk about. I'm closing the public hearing and bringing it back to the commissioners. This has probably been one of the funnest appeals I've done. I lost control. And I want to, just before I let you all go forward, I want to make a suggestion here. Unless the evidence is in the record, he cannot file an appeal to the supervisors and bring that evidence forward with him. He's got an email documenting that that evidence exists, but he didn't present it to us. Therefore, that means it cannot be viewed by the supervisors. Is it possible for us to leave, if we did not approve of this today? I don't know what everybody's doing, just to be straight up. If we did not approve of this today and he was to appeal it to the supervisors, could we leave a provision in there for them to look at his email that he's sending to Paul as of evidence right now with extracting that computer?
I mean,
Or
because,
no?
well, since we don't know what the evidence is, if the Board of Super, oh, sorry.
You got it on. Yeah.
If the Board of,
Lean into it.
I need coffee. If the Board of Supervisors looks at the new evidence and feels that it would make a difference in their decision, since you haven't already seen it, you don't know what it says, they would, under the county code, have to send it back to the planning commission for consideration.
Okay.
So if you feel that evidence is something that you need to see in order to make a decision, you can continue the hearing so he can bring it, or you can say he didn't bring it, so it doesn't count, and not look at it today.
Okay.
Okay?
Okay.
But once you decide that you want to, the board wouldn't have a choice but to send it back.
Okay.
For your consideration if they thought it was
You
important.
all understand that? If we need, okay, if we wanted to see that further evidence that exists, that.
This is a test, right?
This is a test. Come on, I'm gonna get you all some chocolate in here.
Wake up.
Okay, so if you wanted to see that further evidence that he technically should have had here at this appeal because the deadline has come for his appeal, and let's take into a fact that he also got a continuance, so he had further time than most people to bring his evidence forward. So if you felt you needed more evidence, we could continue this hearing to see it. But he's been given already a more time for that continuance that we granted.
So this email that he's talking about is something that
Showing
proves he's sent his hard drive in to be extracted, and that if it's extracted, it will show.
Photos, previous grows, previous years, proving that he's been growing on this property for an extended period of years.
That he had not given photos.
That he
had
didn't
not
take,
given to the
that he
planning
didn't
board.
take pictures of because he was afraid the federal government would arrest him.
But he didn't, in any event, had not shown them to the planning department.
Correct. So he's here before you today with an appeal telling you that that stuff exists. I'll tell you what, while you're thinking, I'm going to start with Commissioner Laddish because he appears to have something to say.
Well, I don't know that anyone will want to hear it. I think this is a confusing enough situation that I'd like to reboot the planning department's presentation. We were not presented with the pictures of the plants in the garage, which now becomes a very key thing. I don't know that the planning department has had a chance to fully consider if we were to accept the picture in the garage, which is apparently the only picture that was actually taken on the date that's on the other photos, what that effect would have on our situation. Also, we have the additional testimony that's been given as far as the lease goes. Right now, I would have a hard time making a decision in this case, and then it would also give a chance for them to get that other evidence in.
Okay. So
That's where I'm going.
I'm going to just remind you that we could edit the resolution and remove the evidence of the photos and rule based on the invalid lease. So you still have a reason for denial.
Well,
Madam Chair, mind if I address Mr. Laddish's comments? real
Please
quick?
do.
Just to narrow the scope of the issues here, Paul presented 7 photos, all of which had false date stamps on them. The remaining photos, which you have now viewed, do not contain evidence of cultivation commensurate with 22,000 square feet. So the application, as it was submitted, did not contain evidence of cultivation prior to May 10th. That was adequate to prove that he was going to grow in a 22,000 square foot area.
Okay, so basically you're saying if all we'd gotten was that picture in the garage, that would have not been sufficient, even if we disregard the inaccurate dates on all the other pictures that eventually were submitted.
Yeah,
That's
correct. And I'd also point out that the Board of Supervisors on Tuesday heard the Conejo hearing, and then you guys also heard that one about a month ago. And that one, we had to remove evidence of cultivation prior to May 10th because it was false and misleading. And this commission and the board ruled that additional evidence could not later be provided to fill that gap.
No, I'm just talking about the evidence he did submit that
Okay,
we didn't
right.
see until after that. Okay. And there's no change from the planning department's position of anything having to do with a lease that came forward today.
I can't say that there is. And in respect to those photos, we're left with one photograph that we're talking about. All of the rest seem to have been falsified on June 30th.
And the one photo we're left with is dated June 30th. It was printed the day of. It was not printed pre-May 10th.
No.
It was not taken.
It has the false date, I believe, of March 28th.
The garage photograph, I was ready to accept as being valid March 28th. I mean, that was a part of the file as
That's the garage
submitted
out
in June, correct? The photograph that was taken within
Yeah,
the
it
garage.
was submitted, yes. it
So
came-
I mean, if we had photographs taken at that time, and we believe that indeed it was on that garage, on that property, and there were commensurate amounts of plants to fit the 22,000 canopy, that would have been sufficient photographic evidence.
But
But here
that
we
one
have
photo-
one photograph, apparently properly dated, but doesn't show enough. Is that
Correct.
got it?
Single, right?
Yes, we would agree.
Well, I feel clear now.
Yeah.
Yes. Inside shot? Yeah, motorcycles.
That's
right.
inside
Yeah,
the garage.
yeah. I still have a problem with the language in the ordinance, frankly. The commensurate language. All it says is you have to have evidence, date stamped photos, evidence of grading, of course it wouldn't apply here, earth moving, or cultivation, commensurate with the area proposed to be cultivated. I don't know if that says they have to show photos of, let's say it's 300 plants or whatever the total number is. Maybe it does.
I would have interpreted that language to mean that he could have a whole bunch of clones that are very small plants that, you know, if it looked like there were several hundred of them, then you might be able to infer that once those are planted and reach full size and maturity, some of which, I mean, they can be very large plants, would then occupy 22,000 square feet. But that photo shows, what is it, 14 plants? And it's, I counted, but it looked like around a dozen, slightly more. Certainly wouldn't, regardless of how large
It's
they
about
got.
30.
30, okay, so 30, you'd still have to have them cover a 22,000, a half acre.
Several hundred, right? I
Do,
don't know.
do the receipts that he submitted, do the dates on those?
Receipts, there are quite a number of receipts here. I don't believe we have any problem with the receipts that he submitted as far as the new ballot.
But are any of them dated pre-May 10th, or is everything after the fact?
No, they are dated pre-May 10th. It's March.
Is the
March.
property address correct on those?
These receipts don't actually have an address
Okay.
for the
Okay.
property.
And, you know, it has to be photographic evidence or evidence of cultivation and receipts.
And receipts, that's the
So,
other part.
so even
No, I
if
understand what you're saying. I was just trying to make sure that we've hit every dotted I and T.
But again, the ordinance doesn't say it has to have an address on it.
No, I was
It has to
asking,
be credible, it has to be
Right.
believable, it has to be.
it's,
And this is, this is the challenge that we're faced daily with reviewing this information and why it's taking so long, for one. But, you know, we crafted this language, and I think as Mr. Turner said, to provide credible evidence. Give us what you have to prove to us that you were growing or that you'd prepared your site at the level that you applied for. And so if you're saying, well, I'm applying for 22,000 square feet, that implies that you prepared the site or you previously cultivated 22,000 square feet. And give us what evidence you have, photos, documents, sales receipts, whatever it is, to demonstrate to us. Sometimes it's really easy. You know, you look at the pictures, you look at the aerial photos, hey, clearly they were there. The problem is, most of it is not that easy. And it's a situation like this where you can't really see what was there. You've got some photos that may or may not represent the entirety of the crop. And it's been very challenging for us. In this case, we looked at the photos with the date of March that clearly were not taken in March. And so we just, you know, we didn't really look beyond that, as well as looking at the lease. And we said, you know, these two items don't match what we require for demonstration that they had a valid lease and that they had previously cultivated or prepared the site for 22,000 square feet.
I have a question as far as the history of the statute. I mean, the ordinance was enacted on May 10th. What prior notice did growers have that they were needing to present photographic evidence of what was there before May 10th?
Well, we had a hearing in April, I don't remember the exact date,
The draft,
and there was a draft that had been prepared. Well, first there was a draft that was prepared as a future ordinance that was, we had a large hearing in February. And then the board felt the need to consider adopting an urgency ordinance. We had a hearing in April, I don't remember the exact date, and we had a draft of that. It really wasn't until the date of May 10th that the decision was made to establish that date. And so understandably, it's challenging for some growers that didn't have photographic evidence. How do you create something that wasn't there? And that's been, again, the challenge that we've had as a county, as an agency, to try to review these to say, you know,
So it
does
was
it match?
basically if they were following every news report and every hearing, they could have sensed that maybe they better take some photographs. Is that basically?
Well, I think some probably
I'm not
would
trying to
have
put
that
words in
sense.
your
No, I think that was, you know, certainly those who were really on top of it probably said, I need to provide some documentation. Part of the discussion we were having was, were we going to establish that date, or were we going to have a prior date? Some of it was, well, you had to have grown last season. So that was, there was a lot of give and take during that hearing.
There was a,
Can I ask a question of council? What's the burden of proof situation on this? He's got the burden.
Yes, the appellant has the burden to prove that the planning department incorrectly denied.
And we have taken that, the applicant, the registrant, has the burden of proof to demonstrate to us that they were growing. We can't really infer and do we won't go out there and do other research other than what they have provided and what we have based on our aerial imaging.
Question for Mr. Turner. The ordinance has a definition of cultivation, but it refers to Section 19300.5L of the California Business and Professions Code. I don't have that. But I assume that phrase, that word cultivation as so defined, would include the growing of baby plants in pots?
It does.
Yes.
Okay, and so if we had photographic evidence, date stamped of March 28th, 2016, of whatever number it takes to produce 22,000 square feet of canopy when they're grown, that would have satisfied the ordinance. Is that correct?
I believe so.
But what we have is a picture of our many plants that won't go anywhere near that. Is that correct?
Yeah, I mean, I was just doing the arithmetic in my head, and let's say 30 plants each had 100 square feet of canopy, and that would be very charitable. It still wouldn't be anywhere near the 22,000 square feet.
Thank you.
can I just want to bring this in a little bit. When I'm looking at the resolution, the first thing that they're denying is based on an improperly submitted valid lease. The lease is invalid for a lot of reasons. He doesn't, and you pointed it out earlier, Commissioner Bocelli, about he doesn't live on the property. That was a question I had. He doesn't live there. He lives in Stockton. So the lease is making affirmative statements that don't even exist. I mean, I understand it was a rush to get the lease. So originally, upon submitting his documentation, he submitted an invalid lease. It was a handwritten note, no dates, no start, no finish, no monetary value. So for me, number one applies right off the bat. Then when I flip to number two, we have been submitted so many photos with so many different dates in previous appeal hearings that we have held. When we look at these photos and people are rushing to put a date on them to make up history and they're inaccurate, we have denied. We have upheld the planning department's decision. I think we need to just draw back into what exactly is it that the planning department has denied and for what reasons. Were the photos submitted? Were they accurate? Were they dated properly, or were they misleading? We are sitting here trying to undo a puzzle, and it shouldn't be that difficult. I have not sat through a hearing this difficult with so much confusion. For me, that's misleading in every direction I could possibly imagine. The photos were dated wrong. So for me, I am going to uphold the entire body of this resolution. So let's go down the line. How do you feel about both resolutions? Okay, thank you.
No, I'm basing my decision just on the basis that that photo in the garage was insufficient to establish the grow. Now, that particular photo wasn't false or misleading, so I don't know if we need to have a finding in there that there was not adequate proof of cultivation.
You have 14 photos that were misleading. So you
I
can't
understand.
just pull
Well,
one out
no,
and say there was nothing
Given
misleading.
the special facts of this case, that's the photo I'm looking at.
Okay.
Because I think the special facts of this case, I tend to believe exactly what he said that he was told that day. And go get some better photos. And he went and got what he thought were better photos.
I believe that too.
And it went on, he put the wrong date on it. And that's misleading. I fully agree with that.
So I just want to point out, I think the resolution only brought into play the false and misleading. The planning commission, if it found that the photographic evidence was insufficient, but did not find that it was false or misleading, those are two separate findings. The planning commission could add a finding that the photographic evidence was insufficient under 165 and 3.
That's what I'm suggesting, and I think that's what you were getting at earlier. Given that, I'd feel better about voting for the resolution.
Okay. How about number 1?
Number one, I agree.
Okay. Commissioner Bocelli?
I'm looking at the right. Number 1 is the lease item, correct?
Mm-hmm.
Well, I disagree with the conclusion that it's invalid. I believe that the lease and the other 2 documents taken as a whole would be upheld in a court of law. It's clearly incomplete, the form lease. The fact that it's a residential, I don't think has anything to do with it. I think he actually had the right to be there. I think he's presented a lease that's sufficient. On the photos, the photographic evidence, I think it is misleading. The March 28th, I suspect we'd have a really good case to decide if he'd only submitted the one photo from the garage. Because then you got the question, the only question would be, is that enough? Do you have to have pictures of, I'm using the number 300 plants? How about 250 plants? 200, where's the cutoff? I don't know what the answer is. This is about 30, maybe a little less, 25, 30. That's insufficient. And the others are clearly misleading and were never explained as far as I know. At least not when we submitted them. So I'm going to go with the resolution with those comments about the lease.
I believe that they both have false and misleading information. And the photos that were turned in.
You need to turn your mic on, please.
Okay. I believe that he provided misleading information on the lease and in the photos.
I guess it's my turn. On the lease, I do think that there was a failure to satisfy both 17.95.165 N2B and 17.95.165 A2R because there was no fully executed lease. The handwritten note doesn't qualify under either one. And the other one that was signed actually June 30, not June 3, I don't think retroactively creates a right as of May 10th, if it didn't already exist. And so I'm good with the resolution. I do think the additional citation should be added because I do think it missed on both counts of the ordinance. I also think that there's a failure to satisfy N2 and 3 because the only photo that predates May 10th is only of, say, 30 plants and it doesn't meet the commensurate standard of cultivation, not even close. And I think that should be included in the resolution as a separate ground for denial. And I think when you take 13 pictures that have the wrong date, the lease that has the wrong date of signing, we have a false or misleading situation as well. So I agree with that finding.
I've been keeping score, trying to figure out all the different proposals, and just to summarize and tell me if everybody agrees. It sounds like there are 3 commissioners in favor of upholding based on the lease being insufficient under N2B. There's 3 commissioners that are believing that there were false and misleading photos. 4, let's say false and misleading photos. That there were 5 commissioners feeling like there was insufficient photographic evidence and that should be added. And we have a new proposal that hasn't been addressed to add a 4th finding under A2R regarding the lease. Is that correct?
Well, it would be part of number 1.
Okay. So that's where we
We would just be adding that number to the first
so
finding.
so we would need consensus on whether to invalidate the lease on a second basis or another basis under the urgency ordinance of A2R. So that's what we're still looking for from the rest of the commission.
Yes.
You need a head count?
Well, I'm just trying to keep a track to make.
No, I would disagree with the last item. we
Okay.
are. I think that taken in context, all 3 items together would satisfy it.
I would agree I would agree that R applies as not having been satisfied.
Okay.
I also agree. You agree? Commissioner Sisk agrees. You have 4.
So we have a lot of modification.
The one thing I think we might make clear is I don't see what would be the relevance of the evidence that he would be submitting about prior grows, previous years. Since that was kind of left up in the air, I think
Well,
that's something that I don't see why that would make any
Okay.
difference to us.
So we have a couple of things we need to do. I guess one would be, do we want to amend, let's start with that, and add AQR, is that A2R?
A2R.
And I can read that. A copy of a fully executed lease or a recorded deed demonstrating that the registrant had lawful possession of the parcel to be registered as a cultivation site prior to May 10th, 2016. So the question is, do you want to add that to the findings on number 1?
Yes.
1, 2, no, 3, 4. So 4 yeses to add A2R. The second finding in 2B,
That's the one that's already there.
okay.
Yeah.
So then we're okay on all the rest.
And then I think there was a suggestion that we add an additional finding, and that had to do with the substantial evidence. And I have some suggested language. And this would be a new finding. 1795-165 N3 A and B states, and then we quote that section, which is, the registrant must provide evidence satisfactory to the planning director that no later than May 10th, 2016, she has taken demonstrable steps toward the development of a commercial medical cannabis cultivation site on the parcel as demonstrated by the criteria described in either A or B below, and by at least one of the criteria described in C through K. A, date-stamped photographic evidence of grading and/or earth moving commensurate with the area proposed to be cultivated. B, date-stamped photographic evidence of cultivation commensurate with the area proposed to be cultivated. And the evidence would be, only one photo was submitted that showed cultivation prior to May 10th, 2016. This shows plants grown indoors that is not commensurate with a 22,000 square foot area of mixed light cultivation.
Yes.
That'd be good with me.
Works. Okay. Paul, would you be willing to read that resolution for us as amended?
Absolutely. The staff recommends that the planning commission adopt resolution 2017-017 as amended, denying appeal 2016-959, thereby upholding the planning director's determination to reject application 2016-959.
Thank you. Need a motion?
So moved.
As amended.
As amended. Second.
Thank you. Okay. All in favor, say aye.
Aye.
Opposed? Motion carries 5-0. I have a request to take a break, if you all don't mind, just 10 minutes if we could.
That's good for me.
Are you going to get it? I want, do you want some?
I would love to, and I will give you, because if we don't get back in time, I don't want to be
The bad guy? Okay. No, I can do that.
I love you.
Thanks for the coffee.
Thank you.
I buy, you fly?
I buy, she flies.
Yeah.
I'm all for it. Okay, we're going to reconvene the meeting, and we are going to go to the next hearing, which is also an appeal for cannabis cultivation. Paul, are you going to present this
ma'am.
one as well, please?
Yes, ma'am. Let's see here. Excuse me one second.
Thank you for hanging in there with us all day. We appreciate your patience.
You're very welcome.
All right, this is appeal number 2016562. Actually, let me turn this on. There we go. Okay, this is appeal number 2016562. Mao Zhang is appealing a denial of a commercial cannabis registration by the planning director. Project description and appeal of a denial of a commercial cannabis registration by the planning director. The registration was denied for the following reasons. First, the registrant did not produce evidence that no later than May 10, 2016, cultivation and/or grading or earth moving commensurate with the area proposed to be developed occurred on the site. Second, the registrant failed to obtain a state seller's permit by the September 7th deadline. And the final reason was the application for registration contained false or misleading information. Just to locate ourselves here, the site is 13.37 acres located at 10211 Story Road outside of Mountain Ranch. That's in Township 5 North, Range 13 East, Section 21. It's in District Number 2. As you can see on the map here, Mountain Ranch is here. You go out Whiskey Slide Road onto Ponderosa Way, turn off to whatever it is, Story Road, and your site is located right there. On June 28th, 2016, the applicant Mao Zhang filed a commercial cannabis cultivation registration for 22,000 square feet of outdoor cultivation area. Included in that application was the plot plan you see up on the screen. Just to orient ourselves on the site, I'd like to run through this real quickly. Actually, the boundaries are the yellow going around the outside of the parcel. There's a locked gate right here as you go in the access road. Our cannabis cultivation area are shown to have screen fencing around the cannabis plants, and you can see there are 2 of those on the site right there. Water tanks located there, storage shed located up there. This is a shade structure of some sort, and the well's over there. And then the applicant designates the 75-foot setbacks with the arrows, and also states that the grow is not to exceed 22,000 square feet of canopy area. I'd like to proceed to the first reason for the denial, and that was that the applicant failed to meet the requirements of section 1795 and 165 in 3A through C. That section reads as follows. Number 3, the registrant must provide evidence satisfactory to the planning director that no later than May 10, 2016, he and she has taken demonstrable steps towards the development of a commercial medical cannabis cultivation site on the parcel as demonstrated by criteria described in either A or B below, and by at least one of the criteria described in C through K. A reads date stamp photographic evidence of grading and or earth moving commensurate with the area proposed to be cultivated. B is date stamp photographic evidence of cultivation commensurate with the area, A was date stamp photographic evidence of grading and/or earth moving commensurate with the area proposed to be cultivated. B, date stamp photographic evidence of cultivation commensurate with the area proposed to be cultivated. Dates, and C reads date stamped receipts for equipment and supplies in types and quantities commensurate with commercial cannabis cultivation in the area proposed to be cultivated. Ms. Young submitted 6 photographs dated May 8th, 2016 to show she had taken demonstrable steps towards cultivation. 4 of those photographs showed no cultivation, rather small amounts of wire mesh, stakes, pallets, empty compost bags, a shed, and 2 water storage tanks. However, the other 2 photographs showed a large number of 2 to 3 foot tall cannabis plants growing in what appear to be felt pots enclosed by a 6 foot tall screen fence. And this is one of those 2 photographs. The light isn't all that great, but we do have cannabis plants back here, 2 to 3 foot tall cannabis plants. They are in large black pots. The whole area here is surrounded by this approximately 6 foot tall screen fence. The next photo is much clearer. And again, what you see here are the cannabis plants. They are sitting in these large black containers. These plants are large enough, I want you to notice that they actually cast a shadow in that pot, okay, on the soil contained within the pot. Around the entire cultivation, again, you can see the screen fencing. So we went to compare this with actual aerial photography taken on the parcel. And what I'm going to do is I'm going to move quite a bit forward from May 8th. I'm going to move all the way up to August 20th. So you get an idea of what we would be looking for when we look for the cultivation area. There's the road, there's the existing structure, here's your access drive-in. And you can see at this time, late in the summer, the 2 cultivation areas have been clearly developed. You can see all the cannabis plants inside of the cultivation areas, along with the screen fencing around the cultivation area. Now I want to move back in time, and we're going to move back to May 31st, 2016, and this is a Google aerial taken at that time. Again, this is our parcel, the existing building, the access drive-in, and where previously we saw cultivation areas in the later aerial photography, we really don't see much of anything at this point. And I want to...
Could you go back to, on that
Yeah, can you
one? Yeah, on
go back, yeah, there.
the,
Where
I
it
see
says-
little circles up there.
Where it's
We're
right-
going, okay, hold on here. I would like to move forward to an enlargement of this
Okay.
area right here, and we will discuss that. Here we are, okay? That's that area enlarged. So right here we have approximately, if you were to count them, there's a group here, there's 2 there, I believe there's a couple down here, there's 25 of these, what appear to be empty pots. There are 4 more down here in the other cultivation area that has yet to be developed. There's no grading or earth moving apparent on this site right here. These plants, remember I just discussed how those cannabis plants we saw in the evidence photos were casting a shadow. We don't see any plants or any little black dots in those pots. So we believe that there is no planting in those pots. I don't believe there is any soil in those pots at this time. The colors, it's kind of hard to tell with the light on this photograph, but if you were to sit and look at the photograph on a piece of paper, you'll see that the colors surrounding the pots on the ground bleed right on through to those, bleed right on through to the interior of the pot itself. So I think basically what you got is a round pot structure, doesn't have a bottom, it's filled with soil at a later date. So what we don't see here is grading or earth moving. We do not see cultivation or anything else that's commensurate with an effort to produce a 22,000 square foot grow area. Further, this...
Paul, I'm sorry, can I interrupt and have you go back, please?
Yes, absolutely.
Go back to the one where, there. When you look at what appears to be maybe a small trailer up there by your little circles,
That little white thing, yeah.
it doesn't appear that the grow is up there. It appears that the grow, if you look at where the house location is, and then you see that green area, what is that?
This green area in there?
Okay, see that little tiny trailer? No, come way down, because the
Right
grow is off of the roof of the house on the other photos.
Hold on one second. That is the small little trailer area you were talking
Okay, but
about.
I don't think the grow on the photo that I'm looking at in the other picture,
Let me
it's
go-
not next to that.
August 20.
It's there, okay. So when you look at it, see the big house?
Yeah,
So it's just off of that. Now, when you go back, you're looking at the little trailer at the top instead of the big house at the bottom, right?
the big house at the bottom is outside of the view area in this image right here. To set you up a little better, let me go back to this photograph here, and let's talk about driving in the access road and going up and looping around on the drive area. Okay, you can see the loop in the drive area. And let me move forward. You drive in, you loop around the drive. Those cultivation areas are located off the top of the loop right there. That's your loop, drive. The cultivation areas are located at the top and to the side of the loop. Does that explain it?
Yeah, it helps me a lot.
Yes.
However, if I can interrupt you one,
Yes, sir.
the upper grow area
This one up here, yes,
on
sir.
exhibit or figure 4, which is the second enlarged one that you gave us,
Okay.
does show the circles,
Yeah.
dots, with dots in the middle, but I'll anticipate your next comment. There's not very many circles there. And there's very few circles in the lower grow area, just 2 or 3. So we're back to commensurate.
Yes, we can move back to commensurate. I see, what maybe, what I could conceive as 1 or 2 dots in the middle of those pots, but the majority of them, I really don't see it. That's
I see
maybe
quite a
the way I'm
few,
looking
I
at it,
see
but-
dots in each one,
Do you really?
yes.
There's about 15 plants roughly, and they have dot, just about every one of them has at least 1 dot in the middle,
But like you said, there's only like
but
25.
not enough for,
There's not, and the top area is not
On this
full
one
here.
here.
We'll leave that to your interpretation, and again, we move on to commensurate, correct? And that is the argument here,
Okay.
correct? Okay, are we good? I will
Yeah,
roll
sure.
on. Appreciate the questions. So yes, again, no earth moving, no grading, and what does not appear to be any type of cultivation commensurate with a grow of the 22,000 square feet. Additionally included in the application was this receipt. It's made out to the appellant. It is dated May 6, 2016. This is for soil, and it's for 40 yards, which will cost you $4,051, along with a delivery charge of $825. We add those together. Actually, the total here is $487. That really doesn't make a lot of sense. We're very suspect of this receipt right here. This is pretty much a standard receipt. You can buy a pad like this in the little stationery section of most grocery stores. It doesn't identify a business. So the general gist of this is that the applicant has failed to meet the requirements of 1795, 165, and 3A through C because the applicant has not demonstrated any type of cultivation, grading, earth moving on the site that would be commensurate with the development of that 22,000 square foot cultivation area. Let's see. I'd like to move on to our second 314 denial. This This one grew to be a little bit longer than we initially suspected. The second cause is...
Paul, excuse me, before you go on,
Yeah.
I think the other point that maybe we made in our staff report, but not necessarily in the presentation here, was that the pictures that were dated May 8th show, fairly good-sized plants, fencing up, other improvements, and yet 3 weeks later, on May 31st, none of that is visible on the site. And so that was why we felt that the photos that were submitted did not represent what was actually on the ground there.
Absolutely. Thank you. So on to our second reason for denial here. That is that the appellant failed to meet the requirements of 1795-165 and 5B. And that reads as follows. 5, by September 7, 2016, a registrant with a pending application for registration shall provide verifiable documentation to the planning department demonstrating that the registrant has completed all of the following tasks for the medical cannabis cultivation operation located on the parcel to be registered. B is receipt of a state seller's permit pursuant to California Revenue and Taxation Code 6001. Initially, the registrant did not provide the planning department with a seller's permit in the original submittal, and it was not brought to our office to meet the September 7th deadline. When contacted, the registrant produced a seller's permit dated October 1st, 2016, which you see on the screen right there. And subsequent to the denial, staff did have contact with a lady by the name of Crystal Kesey. She is a consultant for, I believe it's Eastside Environmental. They do work as far as cultural resources and that sort of thing associated with Central Valley Water Control Board. And that consultant informed staff that the seller indeed had obtained a permit prior to September 7th. We requested that that information be brought forward. We did not see that at the time. And subsequent to the continuance of the appeal that was granted by this commission, there was further investigation done into the seller's permit by staff. A query on the Board of Equalization website revealed that an additional seller's permit under the same account dated August 11th, 2016 did exist. That presented some issue. It made us wonder what was going on with this. A follow-up telephone discussion between myself and a woman by the name of Shannon, I don't have the last name because they don't give those out, at the Board of Equalization. In conversation with her, it was discovered that the registrants can actually change the date that appears on the seller's permit right here. That is known as the start date. You can change that at will. It's simply a phone call to the Board of Equalization to request that that date be changed. And that's why, and if you see two different permits that actually have two different dates, that is most likely what has occurred. At some point, there has been a change requested, and there were actually two different dates. The actual date that the registrant applies for their permit is known as a creation date. And as Shannon told me at the time, a complete account history, including the creation date and the original start date and any start date changes, is called a registration review page. It is password protected and only available to the registrant on the BOE website. Based on this information, I contacted the appellant's counsel, Mr. Corollas, and requested a copy of the registration review page. He subsequently provided me with a copy of the August 11th seller's permit, which is the one you see on the screen right there. Thereafter, again, I repeated my request to Mr. Corollas, and I believe it was yesterday he was actually able to provide me with a copy of that registration review page. And I believe all of you should have a copy of that laid out on your desk. It has probably been buried under a lot of stuff by now. And let me see if I can actually find my copy of it. Thank you. God, for some of you. I think this is what I have. So, excuse me one second. What I immediately, it was 4 pages, okay? You can look at, let me move this forward here too. It's 4 pages. I'm going to show you 2 pages up here because they are the ones that really, you have all 4 pages in what we gave you this morning. I'm going to just discuss here basically the first 2 pages. You can see on the upper left-hand corner it is noted as the registration review page. What I immediately went looking for on this review page was that account history. My previous contact with the BOE had told me there should be a history here that shows the creation date, any start date changes, so on and so forth. I didn't find anything that actually said account history on this page. So I'm left wondering, well, what is the creation date? And again, what of the start dates? I called again yesterday. I spoke with a lady by the name, I believe, of Ashley. And Ashley informed me that what we see as the last updated entry, it's up here on the upper right of the first page. And in this case, it reads last updated by Mao Yang on August 11th, 2016 at 5:05:49 p.m. She informed me that that is actually the creation date. That is the date when the application was submitted, when the registrant hits that send button and the account is actually created. And contrary to what this description of last updated would mean to most of us, she stated that that date never changes. That's your true creation date. Other changes may occur to the registration, such as a change in the start date, a change of address, a change of a phone number, but that date never changes. That is your true creation date. And again, the registration review page did not actually list a complete history as to when the account was created and when the start date changes occurred, and so on and so forth. Now, a true history page showing changes in the start dates and so on and so forth is accessible only to the Board of Equalization staff. They can give you information as to changes verbally in relation to certain business organizations, and that's because those would be public record. However, any changes associated with an individual, a sole proprietor, that sort, would be protected by confidentiality.
So Paul, when we get on the page 2 down at the bottom and it has start date 10/1/2016, is that just a date that the BOE is saying this is when the applicant says he or she's going to start their business, or what?
You know, that is, I'm going to say that's pretty much what it is. The start date is a date that would be the date that the registrant, the applicant, first expects to make sales that produce revenue, okay, that are reportable as taxable income or have to be tracked as taxable income. So say I was creating a business, if I was to create, let's say I had created a business 2 months ago. I had failed to get my seller's permit. I would call them up and I'd say, well, I've actually been doing business for 2 months. I started, 2 months ago, February 15th, and they're going to say, well, when did you first do sales that you'll have to report on? I would say February 15th. That's when I started. That would become my start date. Also, if that date would be in the future, say I wanted to start a business June 1st, I would tell them the first time expect revenue, sales, taxable revenue will be June 1st. That will become my start date. Should in the future that date change and I find out that I actually made sales today, I would call them up and say, well, I actually made sales on this date, and will you please change my start date? And they would be perfectly willing to do that.
So the creation date, though, is when the applicant is, I guess you can do this online if that's what you push the
It can
button.
be done online, it can be done verbally by telephone with a representative of the BOE, and again, if you do it verbally and you say, go ahead and create my account, we've completed the application, it's all correct, and you tell
Right.
the representative to create the account, that's when it's created.
Do you know from, I guess it's confidential as far as when this permit was actually issued by the Board of Equalization? I mean,
No, it's not confidential. I would, from what they told me, I would interpret this as actually saying that this account was in fact created on August 11th, 2016. That is the date that they submitted the application and this is created, is the way I understand it.
And the actual issuance of the permit would follow in the next few days?
My understanding of that, that's a good question. My understanding of that is it's instantaneous. Pretty much more or less, if it's done electronically, there would be an exception for if you were applying for a business that required other regulatory approvals. Say something as a firearms business, an alcohol business, anything where the state would have to make sure that you made compliance with these other agencies, much as our ordinance requires the applicant to have compliance, say, with the Water Quality Control Board before we issue our registration. Under those conditions, from what I was told yesterday, it might take an additional 2 to 3 weeks. So in those cases, you know, with those types of businesses, we can't always say that that date we see up there is the last updated or the creation date would apply. But I believe, from what I was told yesterday, to a situation we're dealing with today with Maljon, it would be that August 11th date.
Well, we're dealing with an ordinance that uses the word receipt. It says they have to provide verifiable documentation demonstrating they've completed all the following tasks including receipt of a state seller's permit. Now, am I understanding correctly that once we have a creation date, that equals receipt because they can get a copy anytime they want?
That would be subject, I believe, to your interpretation. I believe previously we have had cases prior here where the applicant actually did not provide a seller's permit, but subsequently was able to bring a seller's permit to us that showed a date that was prior to that September 7th deadline. I believe the commission has accepted that.
That's true. There have been numerous cases where people failed to provide the seller's permit by September 7th, and their registrations were denied. However, there was a case on December 8th heard by this board involving an applicant named Troy DeCoke. He failed to provide the seller's permit by September 7th, but was subsequently able to provide evidence that he had acquired it prior to September 7th. And the board carved out an exception to the September 7th requirement that the Planning Commission receive it by that date. And I guess go ahead and read the part of the findings that are relevant to that. Registrants shall be deemed to have satisfied the application requirements of the urgency ordinance when a failure to submit one of these documents to the planning department is clearly the result of a mistake. The omitted document had been timely procured by the registrant from the issuing agency, and the registrant promptly submitted the mistakenly omitted document to the planning department after learning of the error. In this case, the seller's permit was submitted after the denial and after one continuance of the hearing. So I would leave it up to the commission to determine whether or not that exception should apply. But that is that was the prior ruling on the Troy DeCote case, which was resolution 2016-049.
In that case, as I recall, the testimony was he had it in his pocket and he just forgot. And I was not a member of the board, so I was just observing. He had it in his pocket and he just forgot to put it on the counter.
And there was, I don't remember all the mitigating circumstances, but the commission ended up finding that the omission was an honest mistake and that he had previously acquired it. And then as soon as he found out about the failure to submit it, he submitted it immediately.
Well, in that case, he had in his hand the verifiable documentation. He just didn't include it with the packet he gave the planning department, but he had it physically,
Correct.
in hand. And the commission found that was akin to a clerical error or mistake, which it was. This is a little different.
Yeah, I don't know the circumstance. I don't recall the circumstances of the DeCote case as to whether he physically had a copy or not. And in this case, it's also distinguishable because of the length of time after the applicant was notified of the failure to submit it by September 7th.
Now, how does one go about getting a copy of a seller's permit?
One can print it out off the website as soon as they've acquired it. They can immediately print it out.
So then, as of August 11th of last year, this applicant could have simply printed out a copy.
And they may have. I don't know.
But it wasn't included with the application.
It was
Oh,
not,
it was never turned into.
it was not turned into the planning department by the September 7th.
That's the requirement of that section is that the applicant has received the seller's permit, but that the applicant shall provide verifiable documentation to the planning department by September 7th, 2016. That applicant has received that document.
Correct.
Are we good?
We're good.
Very good. I think we'll just let that lay. Information, I believe that we'll be required to revisit that if need be. I'd like to move on to our final cause for denial here. And that was that the appellant failed to meet the requirements of section 1795 170A.4, and that is, reasons follows. A, registration of a medical cannabis cultivation site pursuant to this chapter may be invalidated by the planning director for any of the following reasons. And 4 is application for a registration containing false or misleading evidence.
I think you're messing with my head today, because that doesn't look like what you just showed us earlier.
Actually, it is still the Google aerial of May 31st.
But that's a much larger grow area.
But let me,
Are you talking about the area on the right?
right
Oh, I'm
here,
on the wrong land.
the land, our site is right here. And the reason I wanted to show you this is because I wanted to show you what a site that actually was under cultivation, had
You haven't
plants,
seen those
had
before.
fencing around it, was actually happened to be directly across the street here. And that's the type of thing we should have been seeing in the aerial for the appellant here based upon the evidence photographs provided. So we don't see the fence structure, we don't see the surrounding fence structure, and we do not see all of the little cannabis dots inside of 2 rectangular grow areas as shown on the site plan.
And the significance of not seeing the fence structure is that their photographs showed a fence structure.
That, I would go along with that, absolutely.
Okay, but if it's okay, I don't know why I'm struggling with these photos. I've been doing this for too long now.
It's been a long day.
Well, when you go back to where you were,
Yes, ma'am.
and if you were in later stages for this year getting your garden going versus the neighboring lot,
Right.
there is still a grow there in that spot. Am I wrong? Or do you guys see it? And then when I'm looking at this,
I think isn't it what we saw earlier with
What
the
you saw
circles
earlier-
is an enlargement from this?
Yeah, this is an enlargement of that. All those little dots are right in here. All those little circles are right in there, and there's 4 of them down there. There's approximately
this is
25 of
still
them right
early
there.
May, and they
This is
still would
May
have been putting their
31st.
plants.
This
in
is
the ground.
actually, guys, this is actually
My birthday.
3 weeks beyond when those evidence photographs were taken.
Taken.
May 8th, okay? It's 3 weeks later, and there's no fence, we don't see a pile of plants in there. We don't see any of that. Good?
Is that in my packet?
Yeah.
Coming up below.
I'm going to move forward. Is everybody with me here?
Yeah.
Very good.
Tell me again the size, this is 22,000?
Yes, I believe that's what it was.
Combination.
22,000 square feet of outdoor cultivation area. So, when we talk about false and misleading information here, I simply want to say that we believe this is false because the date stamp that you see right here, this May 8th date stamp on the photo, it's not representative of the conditions that are actually occurring on the site
Those are small.
even 3 weeks later. That is not correct. These, the date stamp, the cultivation area shown here is not consistent with what we see in the aerial photography taken 3 weeks later. We believe it's misleading because it shows improvements such as the cannabis, the pots, the screen fencing, which were required prior to May 10th, which actually did not occur. And the intent, we believe, was that this was given to us to have us believe that they were in compliance with what Section 1795, 175 in 3B. Do any of you have any questions? That's the end of my presentation. I'd be glad to answer any questions you may have.
There's one more case that's sort of on point here that this commission has heard, and it was also heard by the board, and that was the, I mentioned it earlier, the Corneo case. And in that case, there was false and misleading photographs submitted. The lawyer for the appellant, Charnel James, requested that the commission deem the application incomplete because it now was without secondary evidence, photographic evidence of cultivation prior to May 10th, and asked that the applicant be permitted to supplement the application with new and additional photographs showing that there was cultivation prior to May 10th. This commission and the board both refused to do that. And I just wanted to point that out for everyone.
Hi,
Hello,
welcome.
thank you. My turn?
Your turn.
First of all,
Can you first state your name for the
Peter
record?
Coloris.
Thank you.
Representing the appellant. First thing I want to do is I want to thank you for the continuance that allowed me to recover from my back injury. I appreciated that. I know you didn't have to do that, and you did that, and I appreciate it. To the members of the commission, Madam Chair, Mr. Vice Chair, councils Moss Lewis and Mr. Turner, and not least of all, Mr. Maurer and Mr. Grove. Pardon me for misspeaking.
He's our leader. We like
yes,
him.
Thank you. From one Peter to another. And I appreciate this opportunity to present my client's case to you as we believe them to be, the facts as we believe them to be. First of all, I want to address, I think, the low-hanging fruit here, which is the seller's permit. This shouldn't be that difficult. The document that was presented to you as clarification by Mr. Groh, first of all, speaks for itself. It is very clear. It says that where it says last updated, in this case 8/11/2016, is actually the creation date. Can't be changed. The creation date goes on to say never changes, even when other changes may be made to the record, such as start date, phone number, address, etc. And the start date, or the last updated, is the date the application was submitted. I've done these before. When you submit the application online, you get an almost instantaneous permit to print out to present to whomever it's necessary to present it to. So I think it's very clear that my client did satisfy the requirement of applying for and receiving a seller's permit. The question becomes, well, it wasn't prepared and presented with the package. And if we're using references to other cases as a precedence for what we're going to decide here, as presented by Mr. Turner, I would like to offer something for you to think about. Case number or application number 548. There's a requirement that the indemnification agreement, landowner consent form, be submitted with the application not later than June 30, 2016. This particular case, I'm referring to 548, the landowner consent form was signed on September 15th, 2016, received September 16th, 2016, and a license was issued. So what I'm trying to say here is, in the exercise and discharge of the director's duties as helped by the staff whom he hires to help him exercise his discretion and discharge his duties, there's broad discretion when it comes to the receiving of documents pursuant to the urgency ordinance, as there should be. There should be discretion involved, and that allows the director to weigh in and see if, if I may do something, it doesn't mean I must do something. May is not mandatory. May is suggestive. It's discretionary. So when it comes to this license, the seller's permit, let's assume that it wasn't submitted by the September 7th date. It was applied for and it was received by the state before the 7th, in this case, August 11th. And as precedents in other cases, you should allow the client after the fact to be able to submit that document to complete the application.
On this previous case you were just referring to, was that something that had come before the planning commission and that was a planning commission ruling or a planning director ruling?
The planning director, it was a application that was granted for the license of cultivation.
So it has, as far as we're concerned, it's not a precedent of the planning commission.
No, but it's an example of the director exercising his discretion as he is wont to do. He's allowed to do that in the discharge of his duties. And he did that in that particular case, even though the language of the statute is very clear, requiring that particular document, being the consent form, landowner's consent form, be submitted by the 30th of June. It wasn't, but it was still accepted after the fact, and a license did in fact issue. An interesting thing about this Board of Equalization and the seller's permit is the cultivators here are not subject to paying sales tax. That burden is visited upon the retail seller. The cultivators here are wholesalers, and as such, they are not required to pay sales tax. Nonetheless, that's a requirement in this county for the issuance of the seller's permit, of the license. I just wanted the commission to be mindful of that fact. So, I don't believe the seller's permit, I don't think this should be denied, the issuance of the license should be denied on the basis that the seller's permit somehow created an incomplete filing based on the fact that the director can exercise his discretion in accepting documents pursuant to the issuance of
But
a
the ordinance
ultimate license.
does require, by September 7th, 2016, a registrant with a pending application for registration shall provide verifiable documentation to the planning department demonstrating, amongst other things, the receipt of the seller's permit.
It does. It also says that by June 30th, you must submit a landowner's consent form.
I understand.
Okay, so
But-
it going both ways here, and the director can exercise his discretion, and I think in the case I mentioned, he exercises his discretion to accept the document filed late. I think that he's within his sound discretion to accept this document, which was filed for and received by the client prior to the September 7th. And so that's all I want to say about that right now, unless you have specific questions
So
for me.
that would be within his discretion not to accept it, too. then.
Sure, of course. That's what discretion means.
Could you answer
Okay.
one other question
I
on
would-
this? What was the reason why the documentation about receipt of the seller's permit was not submitted by the September 7th deadline?
It was an oversight. It was a mistake. It was not intended to mislead anyone. It was an oversight, and I don't think anyone caught it. I don't think the counter caught it. It was, again, it was on June 28th, and 2 days prior to the deadline. I'm sure there was as much craziness going on in Mr. Mauer's department 2 days prior to the deadline as it was the date of the deadline. But the application as required was accepted, but I don't know that anyone ever said, hey, you got to submit the document by the 7th. It was in the ordinance, and I think they're deemed to know what the ordinance says.
Well, it's also in the instructions that everybody's given, where it's underlined. Attached copy of California seller's permit, paren, must be received by planning department not later than September 7th, 2016, underlined. So it's in
Understood.
two places.
And the same ordinance says the same language regarding the June 30th requirement for a very important document, the landowner's consent form. And on one hand, you can exercise your discretion and overlook that extremely important document, and then 2 months later say, well, we didn't get this document even though you applied for it, and we're going to deny your application on the basis that you didn't submit the document by September 7th.
If you assume that the planning director chose not to exercise his discretion to accept this late filed document,
Which one?
the seller's permit, and it appears that that's what happened, so far, at least, then on what basis should this commission override the exercise of his discretion?
I just want all things to, I think we have to be consistent when you're allowing an important document to be filed months after the fact, in one instance, and then in another instance not. I think there's an inconsistent application of discretion. I'm not saying that Mr. Mauer did anything wrong. I'm just suggesting that this is a de minimis error. The application was sought, the application was submitted, and it was created on the 11th of August before the deadline. Now, the fact that it wasn't submitted by the 7th shouldn't be a disqualifying factor in the overall scheme of things, unless you simply don't want to approve the license. Then that's a good reason not to. It's like following a car, policeman following a car long enough, you're going to find something to pull them over for, to find a greater infraction inside the vehicle. I'm not saying that's what happened here. I'm just saying that let's try to level the playing field. If you're going to allow an individual to submit a very important document, the landowner consent form, 2 months after the due date, and then not consider that a disqualifying factor and ultimately issue a license, I think we should do the same thing with regards to this seller's permit. Since it was applied for, it was issued, the fact that it wasn't submitted by September 7th is a de minimis failure and should not affect the validity of the seller's permit.
Question?
And the seller's permit is really of no purpose other than a factor or a qualifier to file the application, because the cultivator doesn't pay sales tax. So it's further minimized by that fact.
I think
Do
one
you
of
know
the,
what,
go ahead.
do you know what date the permit, the October dated permit was actually submitted to the planning department?
Which one are we referring to?
The one that was supposedly dated October 1 that we now know was actually issued August.
It was August 11th.
When was it given to the planning department?
Yesterday, I think Paul said.
It doesn't say that in the.
It was, I think it was last,
It says received April
Yes.
12th.
I think you
The
had
actual
that for a
permit,
while.
The copy of the permit.
No, there's a
Okay.
misunderstanding here.
Excuse me. The October 1st seller's permit was received in our office on February 7th of this year.
So that's the first date you've seen any seller's permit.
Yes, sir,
And
that's
then
correct.
in the last day or two, or today, whenever.
And then the August 11th seller's permit was received in our office on March 30th.
But you were not able to verify why you had two different dates until yesterday through the Board of Equalization.
I had actually had some of that conversation a week prior with the BOE. It was my basic understanding that the start dates could be changed.
Okay.
But it all falls within that timeline. Yes,
Okay.
ma'am.
There's a sentence in your report that, actually, I'm switching gears very quickly. Sorry.
It's okay.
When contacted, the registrant produced a seller's permit dated October 1, 2016. Do you know when she was contacted, and was that a very quick response, or are we talking about months later?
Well, that's in his letter here. He's got a dated letter in here that says that.
I can't speak to the date when they were contacted.
Okay.
I can't speak to that, how quickly the response, to the date when they were contacted and how quick the response was. I'm sorry.
Sorry. Go ahead.
It's quite all right. Okay. So, moving on to the question as to demonstrable steps to cultivate. There are some photographs that were submitted that I don't think we saw here today. One of the photographs, and I think in your report, Mr. Groh, you did refer to one of them. The one of them that I'm referring to is the one that showed some bags of soil. And I believe, if I'm not mistaken, you described them as empty bags of soil. And I'm trying to...
It appears to be in the
Yes, right, this is what I'm referring to. And to not to respond directly to Mr. Groh, I'll
Talk to me.
Yes. To my eye, the bags do not look empty, but that's for somebody else to decide.
Can you please give those all to Annette so that they can be passed down and stay
you mind?
within the file of the county?
Yes, of course, absolutely. There is, after some painstaking searching by my client was able to find a receipt dated May 10th of 2016. Total $13,011.89. Now, this was after I said, you got to dig deeper because the receipt you brought me today, this was a while back, a week ago, post date June 30th, May 10th, excuse me. So I have another group of receipts totaling over $15,000 for soil in the month after the May 10th break deadline. So these, or this, may I?
Yes, please.
Shows a receipt issued by Calaveras Garden Supplies on May 10 of last year for soil and something called soil coated BGCOCOBLE. I don't know what that means. For $4,000, the soil above it, $7,700, for a total of $13,011. The other documents I have here, the other sales receipts I have here, If you want to see them, I'll be happy to show them to you, but they post-date the May 10th cutoff date. But they evidence additional soil purchased in the amount of excess of $15,000. So between the two, it's almost $30,000 of soil and soil products, to my mind, would appear to be commensurate with a 22,000-foot grow.
It would appear to be expanding the grow, which that's what Paul was referencing. And when we were looking at the photos, they weren't supposed to continue to expand. So those receipts show us proof that they were expanding after the deadline.
Well, I'm not so sure that's the case. What I'm suggesting here is that the commensurate language,
No.
that the permit was for 22,000 square feet. So my client was stating in her application that I'm going to cultivate at 22,000 square feet, and as evidence of the demonstrable steps and commensurate with the size of the grow, I'm providing a receipt for 432 bags of soil and another 400 bags of other type of soil for a total of 832 bags of soil. And whereas there's really no expert here to say whether or not those two combined is commensurate with a 22,000 square foot grow, I think it's reasonable to assume that it is or close to it. None of us are experts. None of us can testify with any certainty that any number of plants are commensurate with a 22,000 square foot grow. We're all speculating.
But the receipts are ancillary to the basic proof of date stamped photographic evidence of grading and/or earth moving commensurate with the area proposed to be cultivated, or date stamped photographic evidence of cultivation commensurate with the area proposed to be cultivated.
Correct?
So if we could get to the photographs that are dated May 8th, I think that part has to be established before these receipts even become relevant.
Thank you. That photo, first, a little background. My client speaks very, very, very limited English. She was approached by a third party in the parking lot here one day. I'll help you prepare your application. And the application that is in the file is handwritten, beautiful handwriting. It's this third party's handwriting. This third party assisted my client in applying for the licenses. And my client relied on this individual, whose name she doesn't know, doesn't recall, to help her comply with the codes and the requirements for applying for this license. That photograph, that dated May 8th, my client cannot verify with any certainty where that photograph was taken. She knows that she didn't take it. She believes that all of those photographs were taken by this third party. And upon reliance upon those photographs included in the application, my client was taken advantage of by this person. And I don't want to make it sound like this phantom individual out there. It's just this individual that approached her outside in the parking lot one day, volunteered to help her. Well, help her she did in a very bad way. Because these photographs, my client looks at that photograph, she says, I don't know where that was taken. It was in the package that I submitted to the department on the 28th of June. That's a mistake. It shouldn't be there. And I should be able to submit proof that on that date, or before May 10th, that there was activity on the property that is in keeping with the spirit, if not the letter, of that particular statute that says some cultivation must have been taking place by May 10. Her position is that the soil that she's purchased and bringing onto the property is analogous to moving earth around to prepare the land for cultivation.
Do you know when that picture was taken? Dated?
My client has no idea when it was taken.
So we don't know where it was taken?
There's a date on there that says May 8th, and she cannot say with any certainty that that is her property.
Or when the picture was taken.
Or when the, yes, I mean, the photo speaks for itself, whether it speaks truthfully or not, nobody knows.
And can you tell us what happened to the soil that was delivered on the 10th? I mean, what, would it be somewhere that we would be seeing on this?
That,
Aerial
well, we don't
photo?
know that it was delivered on the 10th. We know that it was purchased by on the 10th.
I see.
It could have been delivered on the 10th, but
So in the photos on the 31st, we would have been able to see the piles?
maybe.
And did this individual go to her property when she was assisting her?
Say again, ma'am?
The individual that you spoke of, the ghost individual, did they go to her property?
That I don't know. I'm assuming that they did because those other photographs are the photographs that belong to my client, the bags.
Did your client ever take her own photos at any point in time?
No. She relied solely on this individual.
So the individual was in the parking lot
That's
when the line was formed?
Yeah, it was during lunchtime, and there were a lot of people waiting for the gain entry to the building, and that's where this individual was where she was.
Yeah.
And she noticed my client, approached her, hey, if you need help, I'll be happy to help you, not knowing any better, without digging any deeper.
So every one of those photos are misleading because they're all dated May 8th, and they weren't taken on May 8th. What date
We
did she
don't-
submit her application?
June 28th.
28th, right?
June
So
28th.
those photos were never really taken on June 28th?
I didn't
because-
say that. I said, I was asked a question, were they taken on that date? I said, well, the photographs speak for themselves. It has a date. Now, it's either speaking truthfully or untruthfully. I'm not in a position to be.
Okay, but if she was standing in line and she went out to the parking lot and someone offered to help her on June 28th,
It was prior to that. No, that was the date she submitted her application. That was when the application was already fully complete, well, completed with caution. That was the day she turned it in. Obviously, she had to do things prior to the 28th to make the application ready for submittal. So it was during that process, the application and the gathering of the information process, when my client was approached by this third party to say, hey, I'll help you. She, needing help, said, okay, instead of coming to someone like, well, me, to help her do it according to the requirements of the law, like some of my other clients have done. She did that to her detriment. She did not knowingly and intentionally submit documents that were false. They
So
turned out to be false.
Here's the issue that I'm taking with this. We didn't pass the ordinance until May 10th.
Correct.
So she would not have known on May 8th that those photos need to have been taken and have somebody on her property on May 8th. So you can say that one of them is invalid, but the rest of them are all misleading with their date as well, because on May 10th is when we voted on the urgency ordinance. The photos are dated May 8th. She could not have met the woman in the parking lot between May 8th and 10th and known what the urgency ordinance was going to look like.
You can say that about every photograph submitted pursuant to the
And we
urgency
have,
ordinance.
I've done it probably over 60 times.
Right, no, I know that. But what I'm saying is, you asked a question in the case earlier. Did you know, how did you know
I
that
would,
by the 10th?
would you allow for her to speak to us? She's standing and would like to.
I was just talking to Peter. Peter, I met her June 16th.
She met her on June
June
16th.
16th. Thank you.
Thank you.
I did not see her behind me.
I know, that's what I was
Yeah,
saying. I
thank
was
you.
asking if you would allow for her to.
Sure.
Okay.
So every photograph submitted in support of a pre-May 10 deadline, you could say the same thing to. You could question every photograph that had a date prior to May 10.
Well, so here's why I'm questioning it, because earlier I said to you, did your client take any of these photos? And you told me no. And now she met this person on June 16th, and I don't doubt that that didn't happen. I believe her. But this person submitted misleading photos for her, and all of them are dated May 8th. So this person obviously, or if she didn't take any of the photos and they're all dated May 8th, every one of them are misleading photos. There's no documentation otherwise. So if she met her on June 16th and this woman went to her property and took those photos, all those photos were taken after May 10th, not before.
I think that's a reasonable conclusion.
So they're all misleading.
They could be all misleading.
Okay.
But I want you to know that my client did nothing to mislead this body or the people reviewing the file. That was never her intent. Her intent was to comply fully with all the requirements, as she's done. She spent thousands of dollars, not that that's, everybody involved is in the same situation of spending money.
understand that.
But my client did nothing to intentionally and knowingly misrepresent this body or Mr. Maurer and his people, his fine people, I might add. I've had many opportunities to interact with the counter people and Mr. Maurer, and I have to say they've discharged their duties with impeccable integrity, and you should be proud of them. And they do a very, very good job.
I do have a question on the, when she submitted the photographs done by this other person, didn't she have any question about the dates that were on these photographs? Why?
No.
Because she was aware, would have been aware that they were taken later than May 8th.
Well, she's not, you and I might be. I can read the ordinance and understand it completely, but my client needed somebody's help. Somebody offered the help. She undertook that assistance to her detriment. You know,
She's raising her hand again.
Yeah, what I'm giving to her, I didn't look at the picture this was there. And I don't know how to take any picture. I don't have
I
time to take.
basically said that.
So I think that she took it, by the time she came to my property, she took it, or I don't know, I didn't look at it. I thought she completed it, I just signed it.
Okay, thank you. She didn't take the photos. She didn't realize the photos were an inaccurate representation of what was happening prior to May 10. She's a victim, and she could be, you know, depending on what this body does, she could be severely penalized through, I don't want to say no fault of her own, because I guess a reasonable, prudent person would have probably undertaken to have somebody who knew what they were doing help her, as opposed to an unsolicited third party in the parking lot of the...
Now, in the appeal letter, you say the basis for the instant appeal is there is no evidence to support the planning department's denial of appellant's application. Do you agree with our approach that the applicant has the burden of proof?
Yes, I do. Of course I do.
Can you explain that statement any further at this point, now that we know?
Well, you know, it's what it is. I mean, an appellant has the burden of proof in this case. I have to agree to that. It's what it is.
But you're saying that the basis of the appeal is that there is no evidence to support the planning.
No substantial evidence, I believe. You know, and the evidence is we're hoping to provide today. My client is not going to appeal saying, yeah, everything is true and correct. We don't believe it's all true and correct. We believe that the evidence really doesn't support the ruling of the Planning Commission, and that's why I'm standing here before you today.
You've obviously done your homework very well because you want to reference application 548.
There's another one I could reference.
Okay, so I'm going to reference one. We had a person or a group, I don't even know what you want to call them, that was out there assisting people, made a lot of mistakes for a lot of people. They have appealed us and we have denied them all. So if you want to look at cases on a basis as you're presenting it, I can bring you cases that we've denied the appeals on very similar to what you're referencing. There was an organization out there that was processing people's applications and failed them all. And so we all sat here, these three were not here at that time, so, but Kelly and I were both here, and during that time period, our heart ached. We're human, we get errors, but it completely missed the program and the steps through it. So I will tell you that if you wanted to research those cases, they are there, they were denied based on, we're sorry that someone scammed you. Remember the case where the gentleman had a false lease in the property? Yes. So I'm just letting you know that the cases do exist to uphold our decision here if we choose to deny based on that, because that's what we have done to others.
I understand and I respect that.
I got a question.
Yes.
The plants that are shown on August 20th aerial. When did they go on the ground?
The August 20th, they went in the grounds, well, sometime prior to August 20th.
Right, but was it after May 31? Because when you compare the May 31 photos with the August 20 photos, it doesn't appear that the plants were in the ground by May 31. Is that correct?
I'm having a difficult time identifying much of anything on those two slides. But cultivation is a process. It occurs over time. You don't all of a sudden overnight have 20,000 square feet of plant on a piece of property. It populates over time. And I think it's unreasonable to expect 20,000 square feet of canopy to be present on the property on May 10th. That I don't believe is.
Well, it would be if you are testifying and signing an application that says, I have been growing before May 10th. Now, obviously, if you weren't, you wouldn't have a footprint like that. But if you're going to say that you've always been a grower here in this county for 1, 2, 3, 20 years, you have a footprint already there that you work off year after year. This is obviously a brand new grow because that footprint was never there previous, just 3 months before that. So this was an expanded grow, an expanded footprint, and I don't see any history of it being grown on the year before. And so it is a process. I get that. But as a process, when we have sat here and looked at photo after photo after photo, you can tell that grow was there the year before and the year before. It wasn't, hey, and when you read our urgency ordinance in the very first paragraphs in it, it was a health and safety issue that it was passed under to stop the land grabs and to stop the expansion. And so to me and for me, this falls under one of those that, oh my gosh, hurry up, May 10th, we're going to jump in. This was one of those. And I'm not seeing the evidence of growing before the May 10th. The photos don't prove it to me. The aerial photos don't prove it to me. And if they had been growing 22,000 square feet, I would see the footprint that I see on August back in May, and I don't see it. I mean, I sat here and tried to argue with them, but wait, there's the grow. But as you look at August as a comparison, there's no history of growing year after year.
Well, I'm not sure that it has to be growing year after year.
No,
right?
it does not.
So, correct.
But correct. I'm
Right,
just
so
saying though,
I'm not
but
sure
they
what the
had to
point
be
is.
growing by May 10th.
Right.
They were not growing 22,000 square feet by May 10th.
They have to be taking demonstrable steps toward cultivating, as evidenced by either A, B, or C.
22,000 square feet.
Correct.
That's not there.
A or B.
A or B, and
You can
secondary
then-
evidence such as
Yeah.
sorry,
It's the A or B that's
A or
that's the
B,
problem.
and then,
The
well,
problem
and-
we're
and I-
having is we're not seeing any evidence of cultivation prior to May 10th. At least I'm not. I'm not seeing it in the aerials, and I'm certainly not seeing it in the photographs that were submitted by the applicant.
I'm going to give Peter just a moment here
I
to,
think there's been, and this applicant is not the only one that has been somewhat confused by what the ordinance actually allowed. We had a number of people that had started growing, brand new, and continued to expand their operation. The intent of the ordinance was to freeze things as they were on May 10th. If someone was growing 5,000 feet, they could continue to grow their 5,000 feet. It didn't give them the right to expand that to 22,000, even though that was the maximum that was allowed. If someone was growing 22,000 square feet or had prepared 22,000 square feet of cultivation area by that time, they could continue their operation. So if someone had graded an area that equaled 22,000 square feet, they could then plant that area. Here we have an area that shows, I don't know what that is, but certainly less than 22,000 square feet of some pots on the ground. It doesn't appear to me that there's any plants in there, but even if we took that, and assuming that that was the case on May 10th, this is May 31st, I believe? Yes. So 3 weeks later, don't really know what and this has been the challenge that we've had, what actually was on the ground on May 10th. But let's assume that was May 10th. Maybe there's 8,000 square feet of cultivation area. If that's all that she grew, we probably wouldn't be having this conversation. But it grew well beyond this. And the ordinance did not provide just the fact that they were cultivating, that they could cultivate the maximum amount. They could continue to cultivate that which they prepared or had previously grown. And this is where I think there's been a great confusion amongst a lot of the growers. But the ordinance, to me, is quite clear that it was intended to freeze what was happening at that point in time on May 10th. So if you already prepared the site, had done grading, then you could plant that area because the damage had been done essentially.
Or you had to remove if you over.
Or if you're over, you had to remove. And in this case, there was no grading that had occurred. There was no site preparation for anywhere other than these plots laid out at this date. And the best that we could assume then was that that's what it was on May 10th. Given the fact then that we had these other dated photographs that, obviously the applicant, maybe was misled by this individual, that clearly did not represent what was out there. We just felt that, this wasn't the case. I can also address the other issue that Mr. Colores raised about the other application. If you want me to go into that, I was going to wait for Mr. Colores to finish his presentation before I responded to that. But
Another question.
Yes.
The way this urgency ordinance is set up, you have to have either the evidence of grading or earth moving or of cultivation. And then you have to have one of a number of other things, among them being date-stamped receipts for equipment and supplies, etc. I would count purchases of soil as falling under the receipts for equipment and supplies and not as cultivation. Do you agree? And if not,
Well, that's
why not?
it. Thank you for asking that question, because I was going to pose that question to you. Isn't it possible that acquiring soil and moving onto the property could be considered analogous to moving earth?
No, I don't think so.
Well, if they're not going to be digging, it sounds like it's exactly analogous to it.
Except
Not that it matters in this case, but
in this case, why, as
I
you
agree
say,
with the argument.
it's not clear that when the soil was delivered, and this is just a receipt from May 10th, so.
I would think the earth moving refers to moving earth on the parcel, not bringing soil in from outside and sticking it on the parcel.
Well,
Because if you view earth moving as of the same character of activity as grading, it's talking about something that's going on with the soil on that property. That's what it's about. And I'm having trouble seeing how buying soil can be considered cultivation. What, can you
Well,
speak to that?
I think it's interesting, the statute says demonstrable steps in connection with cultivation as evidenced by A or B and C through J or whatever it is. So demonstrable steps toward cultivating is what needs to be shown. And the statute says, and you can do that one of a couple of ways. And then secondarily, we need to have supporting evidence of that, such as the receipts for the soil. I think
The problem I have with receipts, there's no delivery address. And anybody can get receipts. For me, when I look at those receipts, unless I see a canceled check, which we're not going to get because it's cash, it says it right on the receipt. Because it's cash-based, there is no delivery address. I don't know what property that went to. But if I looked at a photo and I seen this monstrous pile of dirt, I'd say it was delivered there. I look at these photos, I don't see that dirt. So there's no, it doesn't validate anything for me if what I'm...
Well, I understand what you're saying, but I think it's safe to assume that the individual submitting this copy of a receipt is the person to whom the receipt was issued is for thousands of dollars of cash. I don't think, you're not saying that this is a fake receipt, are you?
No, it's a real receipt, but I don't know where it was delivered to. It could have been the parcel next door or across the county. So
It-
for me, you have to understand, we
Yeah.
have sat here and heard every story under the book, every receipt, and then we find out, yeah, that wasn't really to that property. So we have seen it all, and for me, there's no validation.
May I ask my client to answer the question for you? Where happened to this, where was this
Where was the
delivered?
soil and where's
Yeah.
the photo with the soil for evidence? Sure.
Can I just want to clarify something with the A or B versus the C. There are two ways of looking at the receipt evidence in this case. One is he trying to prove that the receipt is further evidence of the cultivation pursuant to A or B? And so the planning commission can look at whether or not it helps his case that there was photographic evidence demonstrating cultivation. There's a second issue that's been raised by the planning department that he didn't have adequate see-through K evidence. And so there's a separate question about whether the receipt satisfied the requirements of the urgency ordinance as supplemental evidence. He does have to have both A or B and C evidence, and I just feel like we're starting to confuse the issues a little bit.
Well, I'm suggesting that it could be both. That this receipt could evidence the A or B plus the C.
She went,
So, when was this delivered to you, this receipt on May 10th? When did you receive it, and did you receive it at your property?
Yeah, we received right away. I don't know why they never,
can you speak at the mic, please, and state your name?
I don't know why they never get us a receipt to Story Road. They just give me a receipt, and I just get them address, like, go to Story Road. And the first time I get them an address, and then like couple days or couple weeks after that, I said just same place. So they just deliver it for me. So, they didn't even say anything like give me a receipt that shipped to Story Road.
Okay. You had
Can I ask a question on that topic? The photo that you presented, the May 8th pair of photos, the lower one shows what we may be calling pots, but they're larger than pots. They're big enclosures, circular enclosures. Is that where the dirt went? Inside these circles?
Can I bring this
What?
closer?
Sure.
I'm not quite understand.
The lower photo,
You talk about this here?
no, the circles.
about these?
Those things on the ground that seem to have, I think they're called marijuana plants in them.
So your question is,
Did the dirt go into those
okay, the dirt that you
enclosures?
purchased, did it go in these containers here on the ground? Yes or no?
Yes, they do.
I thought those pictures were never taken on the property, so I'm really getting confused.
Well,
She doesn't know.
she's,
Yes, they do, but the picture, I didn't take it. The picture is the woman who took it, the pictures. I didn't even know that she took the picture, and by the time I just, they gave me the denied letter, so he, I don't know his name, the guy over there, he just gave me the whole step that you have picture is wrong, something like that. So when I look, I have my son help me look at it, and he told me that the wrong picture, so I didn't even know that I have picture in there.
Okay.
But the lady came over to my property on the same day. She went around, but I think she took a picture, or I don't know, she, give me a picture. After she filled out the application, so just have me sign this page, sign here, this page, sign here, so I didn't even know she put picture in there.
okay.
The receipt here that has a date of May 6th, was this an actual delivery or was this,
I think that one is the one that we can go estimate that how they're gonna deliver it for us, but that they didn't do it, they don't wanna do it because it takes so long, so we don't do it, so that's why we can go buy the bag.
That's an estimate on what it would
Estimate.
cost.
So how much that costs?
And the math is wrong, obviously. If you add the two numbers together, it comes to 4,000.
Right.
I think there's
It'd be
a
a great
zero
estimate.
missing or something. Comes to 4,876 instead of 487.00. So there was a error in addition.
Question, did she actually buy 40 yards of dirt?
No, it was an estimate.
She
Did
bought
That's an estimate. Did
40
she actually,
No, according to that receipt that showed, that small receipt, No,
No,
that
no,
wasn't,
physically, actually, did she purchase 40 yards of dirt?
she purchased hundreds of bags of dirt. That receipt I showed you,
I counted 200.
no, there's
I
400
counted
and
200 circles on the completed photo, and I did a little quick math, and it's going to be a lot more than 40 yards of dirt, like 400 yards. So,
Well, the receipt speaks for itself. There, I don't know what happens to my copy.
that's fine.
This one?
Yeah, can I look at that? Okay, so it shows 432 bags at $18, 400 bags at $10.75, a total of 832 bags of soil. And I think the bag of soil in Mr. Grove's report or the file is one of the type of bags that were purchased. I think it's probably 1 square yard, each bag.
And so this is just an estimate, she never
That's an
received-
estimate, that's correct. That's not a receipt.
Yeah, I think it's, a yard is more than a pickup truck.
Cubic, well, it's,
Not my yard, not my pickup.
okay. So it's 400, 800 bags of soil.
I use extremely minimal estimates, I completely forgot about this receipt of 800. I could easily have gotten it to 800, so it's consistent in my mind.
These are bags.
But this was the
Yeah.
one that was turned in saying that she,
Yeah, he says they're a yard in each bag. No, a yard's a lot. A lot more than 40.
Okay.
So,
So do you have anything new or that you could present to us, or any other questions for the commissioners?
well, I'm not sure that, we're not making an issue of that fence, are we? The fence there that,
We understand that it exists somewhere, but not on this property. Is
I
that-
don't know.
Because we didn't see a fence around the grow that we're looking at on the aerials. So there's no fence. Right?
Well, can we see the photograph, the aerial photo?
Yeah, let's take a look. There's a
there's
fence.
fence,
That's August 20th.
Yes.
August 20th, it's a fence.
And on May
not in May.
May 31st, there was no fence. Okay,
No fence.
got it.
I think that the fence, I'm going to go out on a limb here and suggest that, the fence can be corrected at a later date. I mean, if the fence is imperfect, maybe if it's not even there, as long as you put it up.
I don't believe we made an issue out of the fencing,
Okay, so we
did
don't need to talk about the fence. Okay.
Yeah, no,
that's
don't
what I
talk about that.
I was going to talk about it. Okay, we've talked about enough. So,
Okay.
so I think that, without going any further, I know everyone's tired, but at the same time, I want to give my client the opportunity of being heard
Give us whatever.
fullest measure possible. And I understand that you've heard these sob stories before, somebody taken advantage of, and it's a shame.
It is a
it's
shame. We
yeah.
agree with you.
And, but, here it comes, after the but. My client did nothing to misrepresent to this panel or to the director and his staff, was not intending to misrepresent or knowingly misrepresent or lie or deceive anybody. She submitted a document that she believed at the time was complete and accurate. And I think her state of mind is important. It was certainly important in a previous case that was application number 614, where the applicant believed something to be other than it was, and was still allowed to correct the problem. In other words, in this case, and I'm quoting directly from the file notes, registrant believed the green screening fence was sufficient. And they gave her time to fix that based on her erroneous belief. So I think in some measure, the applicant's state of mind is important, especially when it comes to the question about whether or not she misled or misrepresented. If there was a misrepresentation and misleading, it was inadvertent, unintentional, and contrary to her state of mind at the time, which she believed she was acting properly and in conformance with the code. So it's my request that you take notice of the fact, one, that the seller's permit, which ultimately isn't even necessary from the state of California's point of view because she doesn't have any saleable, taxable products for sale, but the fact that even though it's required here, she did apply for it, she did receive it, and she should be given an opportunity after the fact to submit it to complete the application. Secondly, I think that there's some conflict between what those photographs say and what they don't say. And I just hope that this board will resolve any doubt in the favor of my client and allow her to continue to cultivate and have her application moving forward. And I think that's all I have to say at this point.
Thank you.
And I thank you for taking the time. I know it's been a long day. And I thank Mr. Maurer and his staff for doing such a great job in prosecuting and processing all of these applications. It's a tremendous job, and staff is to be commended.
Thank you very much.
You're quite welcome.
Okay. What I'm gonna do right now is I'm gonna actually have Peter speak to the applications, just so that we have some clarity on those, and give us some reasoning behind that, and then we will go to public comment.
Yeah, so Mr. Colares brought up a couple of examples of situations where we have allowed for an applicant to submit a corrected document. I think he referred to specifically an landowner consent form. There have been several occasions where we have been reviewing the document. The form was submitted to the county, and we realized that maybe the signatures didn't match up properly. Perhaps the owner signed it as an individual, but the land was actually in a trust or a corporation. So we've required them to come back and make sure that those documents correlated properly with the true ownership. I don't know what the specific situation was with that one that he referenced, but typically the case has been the document has been provided to us, and we say, wait a second, we've got a little bit of a problem here. If it was just simply lacking, we would have said, I'm sorry, it's not here. We also, I think he referred to a situation where a fence was able to be corrected, and we've had several instances before this commission where inspections were made, an applicant was given an opportunity to correct. In some cases, they failed to do so, and so the application was denied. In other cases, they fixed the fence and were able to move forward. So again, it was that sort of at the discretion of the code enforcement official in the field saying, well, this is, you made a good attempt at it here, but the gate's not very secure, or it's not tall enough, or whatever the situation was. So there have been situations where we have allowed resubmittals of documents.
Well, we've done that here through the appeals as well.
And as the one incident that was pointed out, that we said, well, you had it, it was an inadvertent oversight, and that was able to be accepted. I don't have a strong position on that. It's up to your discretion as far as whether you think the timing is critical. They apparently did have a seller's permit or it applied, and it didn't get submitted to us for one reason or another. And until we brought it to their attention, they didn't realize that was here. So either way you want to go on that, it's up to you. The issue here to me is that, yes, it's unfortunate that the individual that she hired to assist her misled her and submitted bad information. But the reality is that she was not cultivating 22,000 square feet and had not prepared to cultivate 22,000 square feet on May 10th, which was the deadline for that. And yet she expanded the garden substantially, more than doubled it. and that is simply not permitted under the code. We didn't have evidence in our file, and whether you want to accept some late evidence, we still don't really have evidence that she was growing or prepared the site of 22,000 square feet on May 10th. That's all I have.
Thank you. Is there any public comment on this agenda item? Seeing none, I'm going to go ahead and close the hearing and bring it back, I guess, just to make sure you had no rebuttal to what Peter said. You don't have to.
No, I don't.
I just want to make sure we're clear
I
here.
appreciate that opportunity to be heard on that issue. I'm not sure on the one case that I cited regarding the landowner's consent form. I'm not positive that it was incomplete when it was submitted. My recollection was that it wasn't submitted, but it may be the case that it was incomplete and that the party was given an opportunity to make the application or the file complete. Either way, though, it was still allowed after the fact, and that's an inescapable fact. That's all I want to say about that.
Thank you very much. Okay, we will close the hearing, bring it back to the commissioners. I don't know if anybody else wants to start, but I can speak.
I just have the same question I've asked before. I think, Paul, you said it was February when you first got the seller's permit,
Let me check the date.
and you eventually figured out it was an August 11th date.
February 7th was when the document was submitted to us. February 7th,
Okay, the first time you saw a seller's permit?
yes.
And how much time had elapsed from when you had figured out that she hadn't submitted it and told her? Was it a 1 month delay, a week, 2 months?
I'm not sure when the file was reviewed and when that.
Because it looks like she actually got it in August.
Probably she was first notified of that when she received the denial letter, which would have been, if the appeal was filed, I believe on the 24th, would have been not more than 15 days before that. So it probably would have been shortly before February 7th.
The first letter that
Okay, so
Paul...
essentially, as soon as she found out, relatively quickly, she got to you the seller's permit that she had obtained in August.
The denial is dated February 8th.
Yes, I would assume that as soon as she had received the denial letter that the seller's permit came back.
So it's not a case of her sitting on her hands 3 or 4 or 5 months, which is what I thought this was at first.
No, I would not say
She
that.
omitted the seller's permit when she submitted the paperwork somehow, even though she had obtained it. Even though she had obtained it before September.
She had, it appears she had made the electronic submittal on August 11th, 2016.
It seems to me we could go down a slippery slope of, well, just how much excuse can we give to, say, non-filing of the seller's permit? I understand, and I understand from what you said, and what I witnessed here was that earlier case in December was a very special circumstance. The guy actually had his seller's permit with him in his pocket or whatever, intended to pass it over, and somehow it wasn't part of the transaction. And I think it's quite different when there's just no, I mean, there's a seller's permit in existence, but it isn't presented or intended to be presented as that September 7th date. I think this is a very, very sad circumstance that somebody offered help and actually created a disaster. But as the director has pointed out, the ordinance was not complied with as far as the actual cultivation level that was being prepared as of May 10th. So I'm ready to deny the appeal on all the bases, except I think we need to work on the evidence on the seller's permit.
I feel differently. I was part of the hearing on December 8th, and I believe that when we ruled on that, we felt as long as they complied with it before September 7th and they had received that seller's permit, that we were willing to accept those. And that was kind of the direction that we gave to Peter and staff, was as long as you make the call and they can show they have it and present it to you. I think we were a little bit forgiving at the time. We have a different commission now. But in consistencies in rulings, the seller's permit, she complied. She went and got it. She can prove she got it. That part of it, I would probably rule the same as I did December 8th. She immediately, upon figuring out she didn't submit it to the county, was able to do so. On the growing portion of this and the misleading photos, that I would rule against. I can see expansions of the grow. I can see that there are some issues there. It is very heartbreaking that we have people out there that have jumped in to scam. I mean, but I have been very vocal about, if you're growing in our county, I expect you to be extremely responsible as a business owner. This is not a lighthearted business. This is a serious business. It brings crime with it at times. We've all witnessed it last summer. And I would hope that you understand the ordinance, you can follow the ordinance, and that's been my position. I don't think I'm going to change on that. I expect people that are going to jump into this business to be responsible to follow these rules, and that's my position. So as far as the seller's permit, I would be forgiving because she actually followed through. We've had many of them come before us that they've got it on September 20th or October or November. They did not get it before the September 7th date. She did. I give her credit for doing that.
Perhaps I misunderstood what the basis of the ruling was in December. I guess what I would like is, what is the planning department's position? Given the facts we now know that she did have a seller's permit,
I can
but did not
clarify that
present.
decision a little bit if you want.
Well,
One of the distinguishing factors was that on Mr. Duco's case, it was the sole basis of his denial. It was a seller's permit. And the finding said where the applicant has substantially complied with all other application requirements and operational restrictions to date, a registrant shall be deemed to have satisfied the application requirements of the urgency ordinance when, 1, a failure to submit one of these documents to the planning department is clearly the result of a mistake. 2, the omitted document had been timely produced or procured, by the registrant from the issuing agency. And 3, the registrant promptly submitted the mistakenly omitted document to the planning department after learning of the error. And if you found that this applicant didn't otherwise substantially comply, then it wouldn't fit within the exception that you created.
I appreciate the fact that you're somewhat supporting my position I recently stated, but I emotionally, I would tend to agree, gee, if they really messed us over here, why, then we might be less lenient over in this next thing. But I think that the fact that it complied with everything else in the December case just went to his good intentions of, as far as the seller's permit. I don't think that can actually affect whether or not there was a violation on the other. But back to the question, what is the department's position? What would you have come in as your position today had you known before all the documents were presented that she actually had a seller's permit?
I don't think we would have included that as part of the denial. Our practice has been that if someone came in late with a document that they had clearly procured before the deadline, we would then accept it.
Okay, well then I would withdraw my being willing to support the denial on the basis of the seller's permit.
It had to be
Fully
dated
agree
before
with-
September
Yeah.
7th was the direction that you were given from the commission. All right,
Thank you.
you've got some eyeballs going on down there. What's up?
Well, this is what happens when you have an urgency ordinance that refers to other statutes. I'm stuck on the definition of cultivation. Does anybody have section 19,300.5L of the Business and Professions Code? Just how broad is that?
Looks like Peter's looking it up.
Well,
Me too.
it may take a while.
Can you give me that number again?
19300.5, it looks like L. It's referred to
You
in
know
the
it?
urgency ordinance and the definitions.
I do have to, I'm not sure whether this is one of, so this was the original medical cannabis recreation or what, Regulation and Safety Act, which after we passed the urgency ordinance got renumbered, so I can't even promise that the definition of cultivation has the same, I don't know if the renumbering started before or after, but we could take a moment to try to look that up.
And maybe now would be a good time to take a break since Susan needs to switch the DVDs.
All right, 10-minute break. We'll get your answer and let Susan get reset up.